Certainly. Good morning, everyone. This trial is in the matter of case number CFI 030-2023 before Justice Andrew Moran. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of the hearing will be issued by the registry on the judge's instructions. The claimants are represented by Al Hayya Al Nubi Advocates and Legal Consultants. Lead counsel is Mrs. Asha Bajoy. The defendants are litigants in person with lead counsel as Mr. Santanu Ghosh. Thank you.
Yes, well, good morning. Just one or two housekeeping matters that I want to raise with you both. I have some concerns about issues that have not been redacted on both sides, in the claimant's case and in the defendant's case, and matters argued in submissions, the skeleton submissions which are presently before me, which may not be relevant to the issues which are for trial this morning that have been determined in my case management order of the 8th of May, 2024. Now, I don't think it is appropriate to delve into that at the moment. I would prefer to hear the way in which you each open the case, first of all, and then I will be better informed as to the relevance of what appears unredacted at the moment, which I am concerned might or ought to be redacted. But I wanted to put you on notice of that matter to begin with, so that you can reflect upon it in due course, and indeed as you are opening your respective cases this morning. The second point is that I have a number of questions to ask concerning matters that I am not clear about, that are not well explained in the pleadings or witness statements, or indeed in the agreements. So that, for example, some of the recitals, and this is just an example, in the STA, I'm going to refer to it as the STA and the MOU, as you have done at various points and stages in the proceedings. Some of the recitals are Stygian, meaning dark and indiscernible in their meaning. So you will need to explain those to me from your respective points of view at some appropriate stage in the proceedings. I'm also concerned, and this relates to a matter which is in the defendant's skeleton argument and is unredacted in its sources, if I can put it that way, in the statements and pleadings before me. And that, Mr. Ghosh, is the section of your opening submissions. I don't want you to answer this at the moment. You can take your time in doing so. From point 3, it's not actually numbered, issue 1, paragraph C on the on page 5 of your, that's internal page 5. I'm using the skeleton arguments as they came in before they were added to the bundle, printed off just for your information, because I annotated them as soon as I got them and read them. Page 5, from paragraph C onwards, which deals with the shareholder resolution of the 31st of December 2020, and all over the next page until the start of issue 2, you are there articulating a matter that is pleaded in paragraph 3AA of the defence at page 290 of the bundle. I'll just go to that and you'll see what I mean. Here you are, as it were, alleging that the claimant number 2 with the director of claimant number 3 have embezzled profits during the years they're mentioned, and then you specify them. Then there is specified, I'm not sure whether you drafted this or not, but there is then specified this allegation, this claim of embezzlement, which is not a matter for trial today. And whether you bring proceedings or whether there are in the proceedings, the other proceedings extant, claims in relation to these allegations of embezzlement, they are not for trial today. And I think you can see that. You're nodding your head in acceptance of that fact. And therefore, I will not be determining those claims of embezzlement in these proceedings which are before me today, one way or the other. I appreciate that there is an issue which is, as one sees this pleading, somewhat poorly defined. What is the effect of signing the shareholder resolution dated 31st of December, and what are the obligations of the parties therefrom? That, as it seemed to me, was simply an issue for me to construe the words of that resolution and to give a ruling in terms what is the meaning and effect of that resolution and the obligations of the parties arising under it. This is not a trial of whether the third defendant was coerced into signing it. That is not on the pleadings and not within the issues as defined. So that may be for another day, but it is not for this trial. I hope that is clear to you. And on that basis, it seems to me that we can, that basis of understanding, which is accepted, it seems that we can begin to open the case, the claimant's case, on the issues that are for trial, which I have obviously prepared in depth for hearing you today. So finally, I should tell you, I did spend the weekend working. I have covered everything that you have asked me to read, both parties, every document that is listed. I have read, and I have read more besides where I have felt it necessary. That does not mean that I have read every page of the 1,343 in the bundle before me. Most notably, I should tell you that many of the authorities which you have made reference to are, of course, very familiar to me. I am an English lawyer by training, and many of the cases are English cases that the parties are referring to. And so I have not gone back to those cases. Rather, it is for you to take me to the selection of the raft of cases which establish the legal points that you want to make before me. At whatever time of your choosing in this trial, each of you consider it to be most appropriate, either in opening or in closing. And you'll have, I hope, plenty of time to develop your arguments as you see fit. Good. So I heard Miss Norton refer to you, Mrs. Bejoy, and I've been calling you Miss Bejoy. Forgive me for that. So, Mrs. Bejoy, you have the floor. Your microphone, unfortunately, is turned off. So if you could turn it on so I can hear you.
Your Honor, am I audible to you?
You are now, yes. You are now.
Thank you very much, Your Honor.
Good.
As a matter of housekeeping, I note that the witnesses are also present in the current hearing.
Yes.
Would we allow them to continue for the opening, or would you want us to make them exit from the opening and then join at the evidence section?
Well, I've not been addressed on this by either of you before, I don't think. Certainly, as a matter of convention, witnesses may be present during opening submissions, but should not be present during the giving of evidence by another witness on the same subject matters. So that would be my approach to it, subject to any persuasion to the contrary either of you may wish to deploy.
May I, Your Lordship? So,
Yes, please do, Mr. Ghosh.
So, when the witnesses of the claimant are there, so I believe there is no bar for the defendant's witnesses to remain there. Well, I mean, the same witnesses from the same side may not be present together.
Yes, that's what I meant. I'm sorry I explained myself badly. So that the witnesses who are in fact certainly in the case of claimant number 2, defendants number 2 and number 3, they are personal individuals. Defendant number 2 is not a witness, but they may be present during opening and the giving of evidence by witnesses on the other side.
Yes. Thank you, Lordship.
Thank you, Your Honor. Good morning, Your Honor.
Good morning, Mrs. B. Joy, again.
Yeah. May I please, Your Honor? So with your kind permission, Your Honor, may I start my opening?
Yes, please do.
Yeah. My name is Asha.
I should just say, you will see me not looking at you sometimes. Just to explain, I think I did before, I have a screen here to my left, a screen in the middle, and a screen to my right. On the left are my notes, in the middle are you all, and on the right is the bundle of documents. So please do not regard it as a discourtesy if I'm not looking at you when you're speaking. I am listening, be assured.
Your Honor, that is the same case with me because I have all my books on one side, the screen on the other side, and the screen that has the attendees to today's hearing in front.
Right.
Yeah, so in between, I would also be changing my head to one direction to look for notes. And I'm believing that Your Honor has no problem with that.
None whatsoever.
Thank you very much, Your Honor. Your Honor, I would like to start off in the conventional way by introducing my name and who I would be representing. So my name is Asha Bijoy, and I'm representing the claimants numbers 1 to 3 in this case. Claimant number 1 for the record of court is the entity Sam Precious Metal FZ-LLC. Claimant number 2 is Mr. Sami Riyad Mohammed Abu Ahmed, and claimant number 3 is Rosie Sun Free Zone Entity. And my learned counsel, opposite counsel, Mr. Ghosh, will be representing the defendants in this case, who are the defendant number 1 is Snyder Private Limited, an entity. Defendant number 2 is Phoebe Leah Tucker, and defendant number 3 is Mr. Shakti Chauhan. And why are we here today? So I will be addressing Your Honor on the reason why all of us are here on this hearing today. We are here to decide whether the claimants are entitled to a sum of US dollars 10,534,414. In this regard, Your Honor, I would like to refer Your Honor to the expert report that is submitted by the claimant, which Your Honor will find on bundle page number 734.
Can I just stop you there and start with one very important matter that you've said there, that you're seeking this relief for the claimants. I appreciate that the claimants 2 and 3 are parties to the proceedings, but what you just referred to, the report, demonstrates that the loss that you are claiming is the company's loss, only the company's loss. So the only effective claimant is the company. Is that not correct?
That's right, Your Honor.
Very well. So we'll refer to the claimant in the singular then, the first claimant.
Yes, first claimant. However, the reason why we have brought in the other claimants also to the proceedings is because the way the documents are drafted in this particular case, the claimant number 2 is not a party to some of the documents that is essential and material to the current case. So because of the peculiar context, it was necessary for us to add claimant number 2 and 3 to the proceeding so that we have...
You don't need to trouble about that. There's been no objection to the joinder. I just want to be sure that the only claimant of damages is claimant number 1.
That's right, Your Honor. Claimant number 1, the entity Sam Precious Metal FZ-LLC. Your Honor, if I may please take you to the quantification of the loss. In that regard, the claimants would like to place reliance on the expert report submitted by experts Grant Thornton, which Your Honor will find on page number 734 of the bundle.
Yes, I've read
737 of the bundle. And the calculated amount is 10,126,813 for the business loss, Your Honor.
Yes.
Apart from that, the claimant is also seeking damages for the loss that they had suffered because of the known closure of the Sharjah entity, which is quantified as US dollars 407,601. Which,
now,
Your Honor,
I'm going to stop you again because despite my searching, I've got the figure, seen the figure, but where is that evidenced and quantified?
Yeah, Your Honor, if I may please take a moment to skip through the file to locate that piece of evidence.
Well, don't worry, carry on with your opening. I don't want to break your thread, but I need to, it may be there, but in the short time I've had, I've not found it. But you tell me at an appropriate time. No doubt you've got somebody helping you there who will brief you in a moment, but please carry on with the rest of your opening.
Yes, Your Honor. For the record, it is there on the pleadings, but we are still, I will, during the course of the hearing, will submit to you the relevant documentation that we have relied on to arrive at this amount of 407,601
Very well.
US dollars. Now, Your Honor, on what basis are we making this claim? It is the claimant's position that the claimants have suffered a loss of the aforesaid amount due to contractual breach of the defendants. And the breach is mostly out of their failure in bringing the 100 kg contractually obliged gold from September 2018 to December 2020. And the reference of this, we would like to place reliance on the MOU, which is dated 27th of March 2018, and the share transfer agreement, which is dated 5th of February 2020.
You're going to address me in due course, I presume, on how those two documents relate to each other, how they interact.
Yes, Your Honor.
That is something that I am concerned about and interested to know the parties' positions on.
Yes, Your Honor. Now, if I may give you a little bit of background about the signing of the Memorandum of Association, which is one of the key documents on which the claimants is placing reliance, I would have to give Your Honor a little bit of background about who Mr. Sami is, that is a second claimant, and in what context Mr. Sami met with the third defendant, Shakti Chauhan. Now, Your Honor, in that regard, the second claimant, Mr. Sami Riyad Mahmood Abu Ahmad, is a chemist by profession and is well known in the gold refining industry for his knowledge, technical expertise, and extensive experience in managing and operating gold refineries. For record, previously, he was a manager of Al Ittihad Gold Refinery, one of the largest gold refineries in the UAE. And prior to that, he was holding senior positions in other refineries. So altogether, he has a total of close to 20 years of experience handling managing and operating refineries in UAE. Now, having worked for many years in the refining industry, Mr. Sami understood certain specific challenges that the industry faces and saw a business opportunity that if he could address these challenges, he could have. In this regard, I would like to briefly give you an overview of what were the specific advantages that Mr. Sami understood. Due to confidentiality and business competitiveness reasoning, I would not be able to give you multiple illustrations. However, for the purposes of today's hearing, I would be giving you one or two illustrations on what was the specific advantage or unique challenge that Mr. Sami wanted to address when he set up SAM Precious Metal FZ-LLC. One such unique challenge that he wanted to address was, unlike other gold hubs in the world, for example, Switzerland, UAE does not provide bullion banks and fund gold purchases for refineries. Mr. Sami realized it, and he realized that if, while setting up the SPM, if he could secure sufficient working capital in the form of gold and maintain it steadily for a longer period of time within his business, it would give him a unique strength in the UAE market. This is more so because, Your Honor, there is lack of funding. Refineries would not have bank funding in UAE because of various reasons. So he understood that if he has solid gold in his custody, this will give him a definite advantage. The other challenge that he understood, which he decided to address when he set up the SPL, was the opportunity to have an immediate exchange of gold. With the 200 kg of gold as working capital, the refinery would be able to immediately exchange pure gold for scrap received from the customers for refining. The business would then earn a higher premium on account of the swift exchange, in addition to the refining charges. Your Honor, the refining activity is one of the key business activities of our client.
You're explaining this, but this is all explained in the expert's report as to the advantage. And in essence, what you're saying is that Mr. Shall I call him Mr. Sami or Mr. Abu Ahmad? Which I'm not. The name is a long name. Which
I think we all call him Mr. Sami, so perhaps it would be better that we call him Mr. Sami.
Well, there are two principal players in these proceedings, and if neither objects, I will call them for shorthand and no disrespect intended whatsoever as Mr. Sami and Mr. Shakti. Will that suffice? Very well.
Yes.
So the point you're making, and I think I have it from the experts' report, is that Mr. Sami, in an environment where there were no bullion banks, as in Switzerland, recognized the advantage of having a fund of gold capital, working capital, to hand, so that he could have an advantage in the purchase of scrap metal, scrap gold metal, in order to enhance the prospects of his refining business.
That's right, Your Honor.
Or of the first claimant's refining business. Is that it in a nutshell?
Yes, Your Honor. And that is also the reason why Mr. Sami was very particular from the beginning that the partner that he identifies should have availability or physical availability of physical gold, which would be available to the business for a term of 5 years without any lien.
Yes.
Your Honor, if I may continue, in
yes,
2018, when Mr. Sami decided to set up his own gold refinery to capitalize on the opportunities as discussed above, he formed SAM Precious Metal FZ-LLC on the 12th of March, 2018, which is also there in the bundle. A copy of the trade license, Your Honor, will find on the bundle on page number 71.
Yes, I've looked at it.
And it also says the issue date is 12th of March, 2018.
Yes.
To give you a little bit of background about the capacity of the refinery, the certified capacity of the gold refinery at the time of its formation was 1,000 kilo. And at the moment...
Over what period? 1,000 kilo?
Per month. Per month, they have the capacity to refine 1,000 kilo scrap gold. So, sorry, yes. Per day, Your Honor. Sorry, I stand corrected. They have the capacity to purify 1,000 kilo of scrap gold on a daily basis when the entity was formed in 2018. And at present, they have a capacity of 2,000 kilo per day.
Yes.
Now, Mr. Sami understood that he would need to retain a minimum of 200 kg, as we discussed, for the specific, the challenges and the unique opportunities that had to be materialized. Now, Mr. Sami had the technical ability and the industry knowledge required to run the business, but he needed a business partner who would be able to bring 200 kg of gold. At this stage, it is important to distinguish, Your Honor, between the contributions, short-term contributions such as short-term capital injections, and independent trades, or gold brought in for refining purposes by clients or even by shareholders, affiliated entities. These would not come into the category of working capital. This is one major distinction.
Can we be specific about this? Because there's a lot, this is one of the areas of confusion. You are referring to working capital. When you are referring to working gold capital, that's when you need to specify gold capital, working gold capital. I do understand the distinction between that form of capital and the day-to-day transactional working capital, which you are drawing a distinction with in this submission you're making to me at the moment. So your point is, this is a separate and distinct requirement of working capital from, shall we call it, ordinary working capital to fund the operation of the business.
Yes, Your Honor. Absolutely, Your Honor. This is exactly the claimant's cases because as a refinery, we will receive short-term capital working capital requirements, and we will also receive hundreds of kilos of gold for refining. But Mr. Sami, as per the MOU, when he entered into the MOU, the expectation was, I need a partner who can promise me gold working capital for a period of 5 years without any lien. That is the requirement, which needs to be clearly distinguished from working capital on a short-term basis, on a regular basis, and the gold that is coming in for trading.
A partner to provide both.
Yes. No, Your Honor, if I may please clarify, the requirement out of the partner was only for the 200 kg working capital, long-term working capital, reserve working capital. But the partner, through its affiliated entities, could also refer clients on a day-to-day basis for regular business. But that is not the working capital that is under dispute.
Very well.
Moving on, Your Honor, then Mr. Sami started looking for business partners and was in discussions with various parties, including potential investors from other countries, such as Canada, and there was also 1 or 2 interest from entities within UAE. This is already recorded on the particulars of claim. If Your Honor would like me to refer to those paragraphs in the particulars of claim, I would be happy.
Yes, just give me the reference. I've read them. I've read them all, and I'm familiar with this part of your case. But just give me the page number for now.
Yeah, Your Honor, it's on the hearing bundle, page number 18, paragraph number 10.
Yes.
And there is also a reference to paragraph number 14 on page number 19. In paragraph number 14, it's more about how the defendant represented to the second claimant that he has access to gold from countries such as Latin America, Africa, etc., which made the second claimant believe that he would be the defendant, the third defendant, and the first defendant would be an ideal partner because they could promise or make available 200 kg gold. That was a prerequisite for the operations of the first claimant.
Yes.
Now, based on the discussions between the parties, an MOU was executed on the 27th of March, 2018. In this regard, if I may please refer Your Honor to the MOU, which Your Honor will find on page number.
I'm working from a hard copy. It's my practice just to let you know I do work mainly from the electronic bundles, but key documents like the MOU, the STA, the resolution of the 31st of December, I have those printed off and well marked, dog-eared, you might say.
Yes, Your Honor. I would also, as an abundant caution, keep a hard copy with me because that makes me quite comfortable to refer to these documents.
We're the
So
same.
if I may please refer to page number 181. The MOU starts at page number 180 of the hearing bundle.
Yes.
And I would just quickly take you through the important aspects of the MOU. As Your Honor can see, the MOU was signed between Mr. Sami Riyad Mahmood Abu Ahmad and Snyder Private Limited. That's on page number 180, the parties to the agreement. The background is also clearly explained. And then the JV company will engage in business and the specific activities as drafted in annexure number 1. Then the most important part is on the share subscription. The MOU goes on to say that the first party owns 100% of the share, which makes it clear that the entity was formed prior to the execution of the MOU. And as part of this joint venture arrangement, the second party wishes to subscribe 50% of the shares, out of which, and the arrangement was that the company will issue an additional 100 shares on premium. Thereby, there will be a 50-50 sharing of the share between the entities, and the second defendant will make a payment of dirhams 100,000 as the share subscription amount and a premium of dirhams 7,245,940.
Sorry. Yes, I have that. Thank you.
And the conditions of the MOU was that, Your Honor, I don't think these conditions are relevant because I will then move to the other important aspect of the MOU, which is the gold advancement clause, which Your Honor will find on page number 183.
That's internal page what of the
MOU, page number 4.
Yes.
The second party, I'm reading out from the gold advancement clause. The second party shall provide 200 kilos of gold to the JV company with 99.99 concentration for the purposes of facilitating the operation of the business gold advancement upon each of the following milestones occurring. The full commencement of operations at the business as confirmed in the written notification, a provision of 10 days notice. Third, completion of the proposed transaction. So these were the prerequisites for the injection of the 200 kg gold. I would also like Your Honor to refer to another important clause in the MOU, which is the JV company consultant, which reads on page number 184 of the bundle and internal page number 5 of the MOU. From the date of gold advancement, Shakti Chauhan will provide consultancy services to the JV company on an ad hoc basis and shall be paid a consultancy fee of 10% of the JV company's net profits for each financial year that the JV company conducts the business. The other clause that is of importance in the MOU, Your Honor, is the lock-in clause, which Your Honor will find on internal page number 6 of the MOU and bundle page reference number 185. And it reads, the first party and the second party agree that they shall not sell any of their shares in the JV company for a period of 5 years from the date of execution of the definitive agreements unless otherwise agreed by the parties in writing. Lock-in period.
Yes.
It is also important to have a look at the board supervision, Your Honor, which is on internal page number 5. This is the page just behind the one that we have currently looked into, which says the board shall have, that's internal page number 5, last paragraph.
Yes. I have it.
Yeah, it reads, the board of directors shall have a supervisory role with respect to the management team. The management team shall be required to obtain approval of the board. And it also talks about the managerial powers of the JV partners and the powers of the management team. Then moving on to the next page, Your Honor, internal page number 7. The important clause is the governing law and the jurisdiction of the agreements. It reads, the definitive agreements contemplated will be governed by the laws and regulations of the Dubai International Financial Center, and any disputes with respect to any definitive agreement shall be subject to the exclusive jurisdiction of the DIFC courts.
Yes.
And the jurisdiction of the MOU is also subject to the DIFC court, which Your Honor will find on internal page number 8 and bundle page reference number 185. That International Financial Center, DIFC, any disputes in respect to the MOU and definitive agreements shall be under the exclusive jurisdiction of the DIFC courts.
Yes. Would this be an appropriate moment, since you're dealing with jurisdiction, for me to raise with you your attempted reliance on the proceedings that you commenced, that were commenced, I'll put it that way, in the Dubai onshore courts, as they're sometimes referred to, and the expert report, because it seems to me that that is wholly irrelevant and something that should not have been obtained, should not be deployed before this court in circumstances where that expert purported to determine issues which the parties have agreed should be within the exclusive jurisdiction of this court in which I am sitting. And therefore, it is the product, let us say, of a breach of the jurisdiction agreement, and it is irrelevant because it usurps the jurisdiction that I am exercising in this trial. Why should I have any regard to it at all? I can tell you it's one document I have deliberately not read beyond the first few sentences. Why is it permissible to rely on it, and why is it relevant evidence for me to consider?
Yeah, first of all, Your Honor, the proceedings before the Dubai court accounting expert is not a substantive proceeding. It is only for the limited purposes of getting an expert appointed and for the expert to review the papers to come to a conclusion. As you can see, no claim has been made in that proceeding. The only objective of that proceeding was only to get a third-party neutral judicial expert to have a look at the documentation and to arrive some kind of a finding. And that is exactly the reason why we felt that keeping a copy of the expert report can have an extraneous or a persuasive impact even for this court, because we are not going by the authority of the Dubai court's findings. Rather, we are only placing reliance on the findings of a technical expert. In this current proceedings also, Your Honor, we have submitted the expert report from GT.
Precisely. And that is what you should have done from the outset. Do you have anything more to say on the admissibility and relevance of this Dubai onshore court expert's report?
No, Your Honor, it's my humble submission that this may be treated as an extraneous or a supportive evidence, a persuasive documentation to give Your Honor the comfort to come to the conclusion that, yes, there is another expert also who has endorsed the same finding of the breach and the resultant damages.
Right.
That was the limited purpose here.
I'm going to rule on this. I don't need to trouble you, Mr. Ghosh, on this. It is wholly impermissible for you to have proceeded in this manner with that report. I shall not consider it. It is inadmissible, irrelevant, and I shall only consider the expert's report from Grant Thornton that you have submitted. So please don't make any further reference to it. Neither party should make any reference to it in cross-examination. I shall not be taking it into account.
Much obliged, Your Honor. Your Honor, moving on to the further aspects of the MOU, we would like to submit that pursuant to the MOU, the parties have acted as per the terms of the MOU. Your Honor, in that regard, the second claimant went on to add the first defendant as a shareholder to the entity by issuing 50% of the shares in the first claimant. And this is recorded on the MOA document of the entity, which Your Honor will find on page number.
You're giving me a list now of actions in conformity with the MOU on which you rely to submit that the parties treated it as binding, notwithstanding the clause within it, which specifically says that it is not binding.
Yes, Your Honor.
You are advancing your case now that that non-binding effect clause has either been waived or the parties, by their conduct, have evinced their intention that this document should bind them all despite that clause.
Yes, Your Honor, because it is one of the arguments advanced by the defendant that the MOU has a specific clause which says it's a non-binding document.
Yes.
And the point that I would like to highlight and submit humbly to Your Honor is that although despite having a non-binding clause in the MOU, which is there towards the end of the MOU, internal page 8 of the MOU document, bundle page number 187, which reads, the binding agreement, the terms of this MOU are not legally binding with the exception of the provisions relating to the following, which shall legally bind the parties. A, confidentiality, B, cause, and C, governing law and jurisdiction of the MOU. It is in this context, Your Honor, that I would like to take Your Honor through the subsequent conduct of the parties after signing the MOU. The most important conduct of both parties is the amendment to the Articles of Association of the existing, the claimant number 1. In that regard, Your Honor, I would like to refer to bundle page number 73, which is the amended Articles of Association of the SAM Precious Metal. Sorry,
you started with the second claimant issuing the shares. Is that item 1 in your list?
Yes, Your Honor.
And you gave me a page reference in the bundle, which was the act of issuing, reflected the fact of him issuing the shares. What page was that bundle number?
Yeah, Your Honor, the document that I would be relying on to establish the fact that the defendant number 1 has been inducted as a shareholder would be an amended version of the AOA of the company, which is starting at page number 73.
So this is what you're taking me to now. Let me look at that. I think I have looked at it.
Your Honor, if I may also refer you to another document prior to referring to the AOA document, because the version of the AOA that we have in the bundle, I realize is an advanced version of the AOA, which shows a later position of the shareholding of the defendant number 1. Other than the...
So what do you want? What do you want me to look at first? Which page?
Your Honor, we would have to rely on the pleadings because, in fact, there were a lot of documents in the bundle, and in the process of deletion, I'm afraid we may have lost that piece of document that shows the payment from the claimant, the defendant number 1 to the claimant for the share subscription, and also the other supporting documentation to show that the payment was made. And the only document that I have left with me in the bundle, the current bundle, is an amended version of the MOA. But from a limited point of view, even this document is also valid because it records that Snyder is a 25% shareholder of the claimant number 1. This is on page number 74 of the bundle, Your Honor. Clause number 6.3.
Yes, but you're troubled at the document that the earlier version of this that showed that he had a 50% shareholding to begin with is not now in the bundle. But I'm sure Mr. Ghosh accepts that there was a previous form of the Articles of Association, which did have the shareholding at 50%.
Yes. And this document, page 74, this is after the share transfer agreement.
That is obvious to me, and I had looked at this. So I don't think you need to trouble about the missing document, Ms. Bejoy. It's not an issue that effect was given to the MOU by the issue of shares. In the first place, the 50-50 split that it provided for.
Yeah, much obliged, Your Honor. And also, if we read the STA, the share transfer agreement, which was entered on the 5th of February 2020, it makes it very clear that as on the date of the STA, if I may please refer Your Honor to the recitals of the STA.
Yes. Item 9.
Item number, yes, Your Honor, internal page number 2. And it says, item number 9, at the date of this agreement, Snyder, that is the first defendant, owns 50% of ordinary shares capital in the company, amounting to 100 ordinary shares.
Yes.
So a reading of the MOU, the STA, and the subsequent amended AOA makes the picture very clear that it was 100% with SAMI in the beginning, then 50% was allocated to SPL, the first defendant, and subsequently, this first defendant has transferred 50% of his share to the third claimant, that is Rosison.
Yes. So that's your first form of conduct that you say illustrates that the parties treated the MOU as binding, that it was their objectively evident common intention to treat it as binding. That I'm not accepting this, you understand. I'm just trying to ease the articulation of your case. Is that it? The first point?
Yes, I'm grateful for the guidance, Your Honor. Yes.
We'll move on then to your next
the next point
piece
is,
of conduct.
Yes. On the second point on the conduct, Your Honor, I would be highlighting to Your Honor the fact that subsequent to the share infusion and introducing the first defendant as a shareholder to the entity, a board was constituted on which adequate representation was given to members of the first defendant. Your Honor, I would again have to place my reliance on one of the board resolutions to show that the first defendant was indeed acting as a board member in the first claimant entity.
I
would like to...
Yes, through a board member. Yes, which page?
Your Honor, in that regard, may I please make a reference to any of the shareholders, share board resolutions, Your Honor, the internal board bundle number 107.
So we have there, Mr. What date is this? 31st of December 2020. So we have Mr. Shakti.
Yes, Your Honor. On the internal page reference number, you would see that this is one of the board resolutions that was passed by the first claimant. And if you look at towards the end of the page, there is a representative from Snyder Private Limited. This was signed by Mr. Shakti Chauhan. And then we also have the other representative.
Sorry, I'm not with you. Where are you pointing me to on page 106?
Your Honor, the next page, 107.
Yes.
Which is towards the end of that page. Your Honor will see the signatories of the board meeting.
Yes.
And out of the signatories, we have Snyder Private Limited, represented by Mr. Shakti Chauhan, which shows that at the time of the board resolution, Snyder was acting as a board member for the first claimant.
Yes, let me just make a note of that. It's page 107. Yes, I have that point. Thank you. Well, also at that stage, Constantino Scandalis, who seems to be called Dino for some reason, not Tino, but Dino. Dino was also a representative of Snyder Prime at that time.
Yes, Your Honor.
And a director, as I understand.
And a director, yes, Your Honor. I would also like, Your Honor, to refer to another board resolution, which is on page number 307. This makes it very clear, Your Honor, because they have all the participants in this board resolution, which is
yes.
bundle number 307, which
yes,
is a board resolution passed on the 27th of May. And if I may refer you to the first part of it, the meeting was attended by shareholders. All the three shareholders were listed there.
Yes.
Sami, Mr. Anuj, and Mr. Shakti, followed by the meeting witnessed by the board of directors. Mr.
Just
Sami.
Pausing there for a moment. Mr. Garg at that stage, this is before the share transfer agreement, is it not?
Your Honor, the date of the resolution is the 27th of May.
No, after it's after. Yes, it's after. I'm sorry, yes.
However, even as on the 27th of May, there were board members representing Snyder in some precious metal board meetings. The same participants such as Mr. Dhruva represented Snyder. Mr. Dino Constantino Scandalis has represented the Snyder. And these are the two members of the board, participant and Mr. Shakti.
So you say they're exercising rights conferred on them, or the first defendant is exercising rights conferred upon it under the MOU.
Yes, Your Honor. And there are other documents also to substantiate that they were participating in all the board meetings and they were exercising their rights as a shareholder and as a board member in the first claimant company. And that is not in dispute, Your Honor. This is only to substantiate to Your Honor that the MOU has been implemented in effect. Yes. And the intention of the parties was always to be bound by the terms of the MOU, which is clear from the conduct of the parties.
Despite what it says on its face.
Yes, Your Honor.
Next, item 3.
Item 3, I would highlight that once they have joined as a shareholder, they have also been benefited by receiving dividends and consultancy fee from the entity. For this, in this regard, Your Honor, I would be referring to page number 193. One of these board resolutions, Your Honor, if I may take Your Honor through the board resolution dated 31st December 2020, which is on page number 193.
Yes, I have it.
This is again a later position after the execution of the STA. However, this would also show that the defendants were receiving dividends and other fees as contemplated under the MOU from the first claimant.
Which part are you specifically referring to? I'm looking at page, oh, I beg your pardon. What was the page? Yes, 193.
Yes, Your Honor, 193.
What do you want me to?
If I may please read you through the board resolution content. It says, as per the half audited financials of the company, the profit for the first 6 months is US $7,315,780. The company proposes the distribution of interim dividend equivalent to 100%, referring to shareholders meeting held on 31st December 2020 and witnessed by board. The profit will be distributed as per agreement made in point number 2.1 and 2. As Snyder Prime Limited has not been able to bring in working capital contribution of 100 kg gold till date, hence the dividend distribution will be as follows for the first 6 months from 2021. This, again, Your Honor, is a later position. However, the background of this discussion makes it very clear that till 2021, they were receiving dividends and consultancy fee from the first claimant company. In that regard, also, Your Honor, I would like to refer to one more document, which is another board resolution, which says very clearly on page number 219 of the bundle, the 31st December board resolution.
If I may, Your Lordship, the numbers are not matching. I mean, the board resolution dates and numbers are not matching with the page numbers. If Ms. Bijoy, is this at page 218 is 25th Feb 2021, if I'm not wrong.
Yeah, that's right. That's right.
Yeah.
I beg your pardon, because that was a mistake. I was only looking at the next page on 219. The document that I was referring to is 218, and it is a resolution dated 25th of February 2021.
Yes. And what are you referring to me here? This is if I may say so, Mrs. B. Joy, not as helpful as your original references, which were before the share transfer agreement. One document certainly illustrates the receipt of dividends and consultancy fees before the share transfer agreement. Which paragraph do you want me to look at on page 219?
Your Honor, on the resolution that is starting on the 218, which runs on from 219 to 220, it is a board resolution dated 25th of February 2021.
Yes,
and I would like Your Honor to please refer
there's no resolution starts on page 218.
It reads to me, dated 25th of February 2021. Mr. Sami Abu Ahmad, shareholder and board of directors meeting.
Yes,
that's how it appears to me in the bundle.
Yes, but there's no resolution on page 218 of the bundle. And then the next page, 219, is the presentation of the financial results for the year ended 31st December. Purpose, introduction, purpose, general meeting.
Yes, Your Honor, I stand corrected. There is no reference to a resolution. It reads shareholders and board of directors meeting. I believe this is a minutes of the meeting of the board.
So that the limited point is you've gone back to simply being the MOU being performed by these representatives of the first defendant being present at a shareholders and board of directors meeting on this date.
Yes, Your Honor, and also would like to emphasize the fact that they have been receiving dividends and the fees as per the terms of the MOU until 2020.
Yes, I have that.
That is the point that I wanted to highlight, Your Honor. Although the document reference number, unfortunately, all of the resolutions that we are focusing in this case is post the STA, the share transfer agreement. And that is the reason why I am not in a position to highlight. However, that is not in dispute. They have not raised any concerns as to the dividend being paid to them, except for the 2020, which I will be explaining to you, Your Honor, in a subsequent in the subsequent submissions.
Yes, I understand that. I don't think it is in dispute that the first defendant received its dividends and the consultancy fees were paid as well until they were not paid.
Yes, Your Honor. So,
just for the record, Mr. Ghosh is nodding to that proposition that I've just put forward. Very well.
Yes, Your Honor. So moving on, the submission that I would like to make in this regard is that the defendant's position that the MOU is a non-binding document is wrong, because the parties' conduct shows very clearly that the MOU was implemented in so many respects. The shares were distributed, dividends were paid, board members were introduced, and in essence, the MOU was implemented. Most of the terms of the MOU has been implemented.
You've dealt with this in your skeleton submission at page 17 in a list. So you say, the MOU and subsequent actions show the parties intended to create legal relations and agreed on all essential terms, including indicating a binding contract. The parties' conduct of share subscription, $2 million payment, commencement of operations, partial gold delivery indicates an intention to be bound by the MOU. The first defendant's delivery of 100 kgs of gold in September 2018, though less than agreed, aligns with the agreement's terms and shows that contracts can form during performance and be inferred from conduct. You put your case rather better there than you've done in the last 2 minutes, with respect, Ms. Bijoy.
Yes, Your Honor. The skeleton speaks it very clearly that the parties have indeed performed the terms of the MOU. Yes. Not to mention, Your Honor, the defendant has also brought in 100 kg of gold that is reflected in the AFS of 2018. However, subsequent to a few months after the commencement of the operations of the claimant number 1, and the claimants acknowledge the contribution of the 100 kg gold by the first defendant.
Yes.
And now I would like to take Your Honor through the next important development in the relationship between the parties, which happens in 2019. So regarding the gold, I would like to make 1 or 2 submissions on how the 100 kg gold was brought in by the first defendant. Your Honor, I have given you a background on what the expectations of Mr. Sami was when he met Mr. Shakti, and what promise Mr. Shakti gave to Mr. Sami regarding the gold availability. However, if you look at the way things have turned out, it is clear that Mr. Shakti did not have the gold availability. In that regard, I would like to highlight, Your Honor, that the facility started its operations in May 2018. However, the gold was brought in September 2018, after almost 3 months of delay. That's on record, Your Honor.
That's from Azil Jewelry.
That's right, Your Honor. Now, the point that I would like to make here is, what was promised by Mr. Shakti was the gold is available with him and he will be bringing it. However, if you look at the manner in which the gold was obtained, it is a loan from a third party. And that is the reason why, if we were to refer to the AFS, it is recorded as a convertible loan from a third party, which Your Honor will find on page number 792 of the bundle, Your Honor. I'm referring to the AFS for the year 2018.
Yes, can I just, before you go to it, and you'll give me that reference again in a minute, I want to ask you about item 7 in the recitals of the STA. Rosie further arranged, this is internal page 2 of the STA. Rosie further arranged through its associates and affiliates the provision of a working capital facility with a face value of 4.9 million to the company for the purposes of facilitating the operation of the business. Now, can I ask this question? I may have got this completely wrong. Is that the 100 kilograms of gold facility that was provided at the outset?
Yes, Your Honor. The 4.9 facility extended by Rosie is through one of its affiliates.
ASEAL.
ASEAL.
Which
That's
is, I think I've read somewhere, is said to be a family company of Mr. Anuj Garg, if I pronounce his name.
That's correct, Your Honor.
Right.
Yes.
So again, there is this imprecision of language that I was complaining about. This is a gold facility, working capital facility. So it's described imprecisely here as a working capital facility of 4.9 million to the company. And that facility was withdrawn the day before the STA. Is that correct?
That's correct, Your Honor.
And it was, as the STA explains, it was substituted with 100 kilograms of gold provided by Mr. Garg as part of the consideration for obtaining the shares. Is that correct?
Correct. Yes, Your Honor.
So what you're going to take me to now, as I understand it, is the documentation relating to the initial provision of that by ASEAL in September 2018. Let's go there then, please.
Yeah.
Page
number 792 of the bundle, Your Honor.
Yes, I have this highlighted.
Yes, Your Honor. Item number 3, that's convertible loans.
It starts, actually, we look at note 17.
Yes.
You need to go back and look at note 17, which informs this. You see, it has balances with related parties, Snyder Prime. That is the convertible loan capital that Snyder Prime, from its own resources, invested, infused is a word that's used by the parties, 1,041,711. And now if we go down to the page you were referring to.
792, Your Honor.
Yes. These are listed.
Loan from third party.
Yes, these are listed together as convertible loans. Gold loan from third party. What's the currency loan from third party then?
Yes, Your Honor, that is why I would like to make a submission on how the initial 100 kg gold was brought by defendant number 1. So the defendant number 1 has made an arrangement with a third party for this 100 kg gold. And that is why in the AFS, it is showing as currency loan from third party. And if you look at the value, Your Honor, it is 4.9 million, which is equivalent to 100 kg of gold in 2018.
Just pause while I make that note. What confused me about this was the previous
entry.
Yes, well,
I would be taking Your Honor through that also.
I understood. I understood the currency loan from the related party. Refer to note 17. That is Snyder Prime's 1.041 million. But above that, there's said to be a gold loan from a third party of 2.050 million, and then the currency loan from a third party, which is in fact, you now tell me, a gold loan from ASEAL.
That's right, Your Honor. There are 3 elements in this convertible loans. Right. The first one, as I understand, is a facility arranged by one of the claimants. The 2.0 million amount is a facility procured by one of the claimants, and that is not in dispute in the current proceeding. Whereas the second item, recorded as currency loan from related party, because Snyder is a related party, it is recorded as currency loan from related party, amounting to a sum of 1,041,711 Why we show that as a related party loan? Because this money has come from Snyder Private Limited. And what was the background behind this? I will refer you to the relevant document in that regard and explain you the context. In that regard, Your Honor, if you may please refer to bundle page number 91, the STA document.
Hang on, we're jumping about here. You started by saying that you were going to show me the source, the documents which demonstrate the source and nature of the gold infusion from ASEAL in September 2018. Can you do that first, please, so that it will be coherent in my note?
Yes, Your Honor. If I may please take a moment to look through the bundle.
Well, you were going to do it, and then I perhaps took you off track, and I apologize for that, by taking you to note 17, so as to identify the middle one of the three convertible loans as the infusion of capital from Snyder Prime. So take your time. I'd like to see the source documentation for the infusion of gold, 100 kilograms of gold, represented here as a currency loan from third party of 4.9 million.
Although my team will locate the documentation for the Al Asil contribution, can I refer Your Honor to clause number 4 of the STA? That would sort of give us a background on this whole transaction, which Your Honor will find on page number 91.
Yes.
And the first clause, 4.1, reads, the working capital facility with a face value of 4.9 arranged by ROSI through its associates and affiliates will be substituted by them with 100 kg of gold, which will continue to be maintained in the company for a term of 5 years from the original commencement of the company operations. So this makes it very clear that the 4.9 million, which is equivalent to 100 kg of gold, was brought in by an associate of Rosie's son. And as part of the STA, they will be pulling off this money and will be returned or replaced by Rosie with 100 kg of gold. I have come across the Al Asil documentation, but however, I am not very sure, Your Honor, whether this is forming a part of this bundle. It's because of various cases and submissions. At this moment, I don't have a copy of that document that substantiates the Al Asil contribution. I believe that's there in one of the other related bundle, but the only document that I could rely on is this STA, which is found on paragraph number 4.1. And if you continue to...
That's how I understood it. That's the only explanation, unless Mr. Ghosh demonstrates a different explanation for what was happening with the STA. That this 4.9 million, very imprecisely and poorly described in this document, it should be the working gold capital facility, or the gold working capital facility, whichever is the appropriate juxtaposition of the words there. This is a reference to gold working capital facility, initially provided by way of a loan of gold from ASEAL, negotiated by or arranged by, when it was provided, Snyder Prime, Mr. Shakti. Correct? Again,
yes,
Mr. Ghosh is nodding. I think, and he'll tell me on the record in a moment, agreeing with my understanding and analysis of what has happened here. Is that correct, Mr. Ghosh? Your microphone is off.
I'm sorry. 4.9 was arranged by Snyder through ASEAL when Anuj Garg, or the claimant number 3, was a preferential shareholder of Snyder Prime Limited.
Yes, that's how I understood it. And you're nodding now, Mrs. Bijoy. It's good to get common ground, as much common ground as we can, because there's a lot of uncommon ground in this case. But here, I think there is some common ground. So what I'm looking at on page 792, as I had deduced for myself by my reading, is the infusions of capital as at the date there shown, 31st of December 2018. There is a gold loan from a third party of 2.05 million, which is something arranged by the claimants and something I'm not concerned with in this case. There is a currency loan from Snyder Prime itself as part of the consideration for the shares of 1.041 million. And finally, there is a misdescribed, and here we can blame the accountants, misdescribed infusion of gold in the form of 100 kilograms arranged by Snyder Prime, Mr. Shakti, through Mr. Anuj Garg at that time, who was a preferential shareholder in Snyder Prime, through, I think I'm right in saying, a family company. I'll refer to it as Azil Jewelry, and there is their 100 kilograms of gold invested in this company. Sam.
I have one point here, Your Lordship.
Yes.
The first one, gold loan from third party. The claimant has to explain from where it has come. We will obviously explain that it has come from Snyder Prime also.
Okay, very well. Well, we'll hear that in evidence in due course.
Yes.
Your Honor, while we are on page number 792, may I take Your Honor through another important submission in that regard, which is clause number 4.2 of the share transfer agreement, which is on bundle number.
Just give me 1 minute. I want to make a note that I. Right. So, Ms. Ghosh, just go back a few steps. You were taking me to something else when I made that note.
That was me, Your Honor, if I may,
yes.
please.
Oh, I'm sorry. Forgive me, Mrs. Bejoy. Yes.
Your Lordship called her Ms. Ghosh.
Ms. Ghosh. Right. Mrs. Bejoy, take me to where you were going.
Yeah, Your Honor, I wanted to bring to your attention clause number 4.2 of the STA.
Yes.
Which is on bundle page reference number 91. Your Honor, we saw the entry of 1.041 million in the financial statement of 18 on page number 792 of the bundle. Yes. Now, I would like Your Honor to also read that along with clause number 4.2 of the share transfer agreement, which makes the picture very clear.
Now, there was a question I had about this, so let me just read it and then I'll ask my question.
May I read it loud, Your Honor, for your...
No, I prefer to read it quietly to myself for a minute, if I may.
Yeah, sure. Thank you.
Right. So you tell me what you say this clause means and intends, what the party intended by it.
Yes. Your Honor, as per the financial statement, it is recorded as currency loan from related party, which is Snyder. An amount is 1,041. And as per the STA, clause 4.2, it reads, Snyder has separately provided US dollar 1.01711 as a working capital facility to the company. It goes
Sorry,
on. The company,
where are
it's
you
on
reading?
4.2 of the STA document, Your Honor, on page number 91.
You're reading the whole clause again. Yes, sorry, I had read it.
4.2.
Yes,
Yes,
Snyder has separately provided that figure as a working capital facility. Yeah.
Yeah, which is the facility that is recorded as currency loan from third party in the AFS, in the annual financial statement of 2018. And the clause goes on to read, the claimant will pay, the company will pay US $291,711 to Snyder following the share transfer referred to in clause 3. So the company is agreeing to pay this amount. Balance of US $750 will be offset against a company receivable from Snyder affiliate, meaning this makes it very clear that this was not a long-term working capital, but this was only a short-term loan facilitated by Snyder for its own trade. And that is the reason why there is an express acknowledgement that the balance will be offset against a company receivable from a Snyder affiliate.
So this was short-term working capital. And what you're saying, if I understand you correctly here, is that this was being repaid to Snyder in part as a cash payment of $291,711 US dollars.
Yes.
And discharging a debt owed by a Snyder affiliate to SAM. Is that correct?
Yes, Your Honor. So why would the company has a receivable from a Snyder affiliate? That could only be possible if Snyder was doing some trade on behalf of SAM. So the point that I would like to highlight to Your Honor is this entire US $1 million owed amount is something, it's an amount that Snyder has utilized for third-party trades through SAM. And it is not a working capital contribution as claimed by the defendants. The long-term gold working capital.
So it's an amount you say Snyder has utilized for third-party trades. That it, what are you saying? That it has conducted on behalf of SAM, or what? What do you say?
Your Honor. Yes, Your Honor. So this being a gold industry, of course, the witnesses would be in a position to clarify the position more. What I was told is that there were trades conducted through affiliate entities on a short-term basis. So this contribution of US $1 million was towards satisfying one such trade.
So trades were conducted through third-party affiliates with SAM, with the claimant, the first claimant.
Yes.
And you're saying these funds were utilized to pay third-party, suppliers of gold?
Yes, Your Honor. So the US $750,000 will be offset against a company receivable, meaning SAM was to receive some payment from a Snyder affiliate. And in order to set off that, we will be using the $750,000.
Thus discharging, discharging the liability of the Snyder affiliate. Wait, let me get this down. So what I've written down in my note is as follows. This is quite complicated, so I want to make sure I've got it right. Trades were conducted through third-party affiliates with SAM, And these funds, this is an illustration of funds being used from short-term capital provided. These funds were utilized to pay third-party suppliers of gold to SAM. The 750,000 here in clause 4.2 was used by the terms of this clause to pay off a debt owed by a Snyder affiliate to SAM.
That's right, Your Honor. That's one level of argument that I would like to advance.
I just want to make it clear, I'm not accepting anything at the moment. I'm just wanting to understand what your case is. So you are trying to persuade me that this 1,041,711 figure here is short-term capital provided by Snyder to SAM for its trading operations and not a long-term investment in the company.
Yes, that is my submission, Your Honor.
And that here in this clause 4.2, that is made evident by the return of some of that capital as cash, short-term capital as cash to Snyder, and the balance being used to pay a debt owed by a Snyder affiliate to SAM.
That's right. That is my humble submission, Your Honor, on that point.
Right. So where is this documented? Is it documented anywhere? Where is this $750,000 debt owed by a Snyder affiliate? Which affiliate was it? Do we have that detail or not? We may not have it. And if we don't, well, I'll have to make of it what I make of it.
Can I revert to Your Honor on that?
You can come back. You can come back on it if you wish.
I'm sure.
But at the moment, I have your submission on it, and in due course, I'll hear from Mr. Ghosh on what he has to say about it. Right. Where would you like to go next?
Yes, Your Honor. So we have gone through the MOU and the STA, and now I would be looking through the 31st December 2020 board resolution submissions in relation to that. So the point that I wanted to conclude by referring to the MOU and the STA is that there is no documents on evidence that shows that the defendant has brought in 100 kg of gold working capital for a term of 5 years.
From it, you mean from its own resources?
From its own resources. The only arrangement,
gold.
Yes, Your Honor. And the only arrangement which the defendant number did was to arrange for a loan of 4.9 million through a third party. And that is the reason why it is recorded in the annual financial statement as a currency loan from third party. So that goes to our basic case that there was a binding obligation and that obligation was not performed. There is a breach. And because of that breach, our clients have suffered business loss. Your Honor, the position here is our case is that the defendant has brought in only 100 kg, where he was supposed to bring in 200 kg.
Well, it's more than that, isn't it? Your case is that he was supposed to bring in 100 kg of gold from his own resources that would remain with the business for 5 years. Sorry, 200 kg of gold that would remain with the business for 5 years. And instead, what he's done is he brought in, by way of a loan of gold from a third party, 100 kgs only, instead of the 200 kgs that you say, contracted to provide from his own gold resources.
That's correct, Your Honor. That is our case.
Right.
To put it very simply.
So that the gold that was brought in was less than should have been brought in, and it was not secure because it was by way of a loan only.
It was by way of a loan, and because of that, he could not exercise any control on the availability of this gold for a term of 5 years.
Yes.
Um,
And I will hear the evidence on that in due course.
yes, Your Honor.
On both sides.
Yes. Moving on, Your Honor, I would also like to highlight certain relevant sections from the STA document. The background behind the STA, which is very clear that towards the end of the 2019, the gold arrangement obtained by the first defendant could not be continued. And therefore, he had to get into an arrangement with the Mr. Rosie's son, so that there could be an alternative arrangement for availability of the 100 kg gold. And that is why, if you look at the STA, Your Honor, it says in 4.1 that the 4.9 million arranged by Rosie through his associates will be substituted by them with 100 kg of gold, which will continue and be maintained in the company for a term of 5 years. So in STA, two things happened. One, the gold that was arranged by the defendant number 1 till then was returned or taken away. Instead, a new partner was introduced as Rosie's son into the business by the first defendant transferring 50% of its share. And that transfer was subject to two conditions. One, they have to provide 100 kg of gold, which will be maintained in the business for 5 years. Secondly, the dividends eligibility of the first defendant will be distributed 50% to the new shareholder, which is taking up 25% shareholding in SAM.
Yes.
That is recorded very well on clause number 5 of the STA, Your Honor. Now, another thing which is also important in the STA is STA did provide an opportunity for the first defendant to bring the 100 kg of gold. And this is on clause number
4.2.
4.2, Your Honor. It reads that the Snyder will provide the company with 100 kg by 31st December 2020 to be maintained at the company for a final term of 5 years from original commencement operations. So STA, in fact, gave an opportunity for the defendant to bring the gold until end of 31st December 2020.
I'm perplexed. Why do you refer to it as an opportunity? This, you are contending, in your subsequent case, is an obligation. Snyder will provide the company with 100 kilograms of gold to be maintained to a final term of 5 years from original commencement of the company's operations. Why is that an opportunity rather than an obligation? What is it?
Yeah, Your Honor, it is an obligation. The STA document clearly acknowledges that the obligation to bring the gold continues even on the signing of the STA.
Yes. This is why I've put you both on notice at the outset of my requirement to you both to explain the relationship between these two documents, the MOU and the STA, because your case, as revealed by all of the documents, but particularly so in the experts' report, is that there was a continuing failure from September 2018 on the part of Snyder Prime to provide 200 kilograms of gold. However, this STA, on one construction, it is arguable that it is a variation, a modification of the obligation to bring in 200 kilograms of gold. That if you are right that there was a binding obligation under the MOU until the STA to bring in 200 kilograms of gold, and the failure to bring in 100 kilograms of it between September 2018 and the date of the STA has resulted in a loss calculated by reference to a shortfall of 100 kilograms of gold in that period. what happened with the STA, it is arguable, and I want your comments on this possibility, was a variation that after the STA, the obligation to bring in 200 kilograms of gold that you say existed for Snyder was changed to an obligation from that date to bring in 100 kilograms of gold. From the STA, from the time of the STA, it was not under an obligation to bring in 200 kilograms of gold. It was under an obligation to bring in 100 kilograms of gold. I'm not saying I've concluded that, but I want to put that construction to you both, because I have to get to a just result here. And what your expert has done is to calculate the period of loss from over the whole period, not just to the date of the STA. You see, he's calculated the failure to bring in 100 kilograms of gold and its effect right through until the end of the loss period, which is the 31st of December 2020.
Yes, Your Honor.
So I want you to consider, that's why I said to you, I want you to make submissions on what you say the interrelationship is between the MOU and the STA. What are the obligations that existed before it and the obligations that existed after it? Because after the STA, on one construction of it, Snyder was not obliged to produce any gold until the 31st of December 2020. It failed to produce gold. I know that's your case by that date. And then we have the resolution of the 31st of December 2020. But the STA, on one construction of it, seems to have modified what the MOU obligation was. Do you see my point?
Yes, Your Honor. If I may please address you on that point.
Well, you need to consider it. I appreciate that that may have taken you by surprise, but I think as I articulate it to you, you are understanding what the difficulty is here, and it's something you must grapple with, both of you.
Your Honor, I would like to make a submission, small submission in that regard, because
yes,
if you look at the MOU, as per the MOU, Snyder has become a 50% shareholder of the first claimant. And the obligation of 200 kg was when Snyder was introduced as a 50% shareholder. So that continued until end of 2019. And in 20, what happened is, because of the further share transfer, the Snyder's overall share capital in the business has come down to 25%. So from the original 50%, he went down to 25%. So while he was a 50% shareholder, he was obliged to bring 200 kg. It is only natural that when his shareholding comes down to 25%, then his obligation to bring the 200 kg gold also comes down to 100 kg. And that has been clarified in the STA document by saying, why did we do that? Because the business requires gold. And that 100 kg requirement of the gold has been taken up by Rosie Sen, who has taken up the 25% shareholding in the first claimant. So that 100 kg has already come into the business. Now, the shortfall of the 100 kg, the business still wanted Mr. Shakti to bring in because it is a continuing obligation as per the MOU that he would bring gold.
But you gave him till the 31st of December to bring in that gold under the terms of this agreement. Snyder will provide the company with 100 kgs by 31st of December 2020. And therefore, he wasn't in breach. This is all assuming he was ever in breach. Snyder Prime wasn't in breach. of the failure. It wasn't in breach by a failure to bring in the gold until it failed to do so by the 31st of December 2020. That's what's concerning me.
I'm with you, Your Honor. The submission is that, see, the requirement of the business is 200 kg gold. And what we have to look is, has the defendant brought this 200 kg gold during the time period that starts from 2018 till 31st August 2023? That was the commitment given by the defendant. Now, in between, there are some transactions. For example, MOU started, the business started in 2018, September, and until end of 2019, defendant did manage to make some third-party arrangement for availability of the 100 kg gold. In 2019 or the beginning of the 2020, because of the share transfer, Snyder's original obligation of the 100 kg was taken up by Rosie's son. So Rosie brought 100 kg. From a business point of view, still there is a shortfall of 100 kg gold. And that is the reason why STA emphasized the importance of Snyder bringing the balance 100 kg.
But as I say again, only before the 31st of December 2020. You gave him 12 months, or you gave Snyder, I keep saying him because obviously we're dealing with personal actors behind these companies, and we're talking here about Mr. Shakti. You gave Mr. Shakti and Snyder Prime, on the face of this document, to the 31st of December 2020 to bring in the 100 kilograms of gold that he had not brought in to the company.
In fact, Your Honor, we did not limit the time period to December 2020. The original understanding as per the MOU continues till August 2023. What we have highlighted in the STA is that if you bring the gold before December 2020, I would refer Your Honor to look at the 31st December 2020 to understand, resolution to understand why the 31st December 2020 time period assumes importance. Because if from 31st December 2020 resolution onwards, there is a redistribution of the dividend of Mr. Shakti because of the failure in bringing the gold even within the timeline of 31st December 2020, whereas the time period from February 2020 till December 2020, there is no redistribution of the dividend. Because
no, but that's the point, isn't it? That's at a different time. And what I'm focusing on here is the quantification of loss. If he was not in breach because the MOU had been modified by clause 4.2 of the STA, then no loss flowed from that date until the end of the loss period, which is the 31st of December 2020. And the loss for his breach, if there was a breach of the MOU, and if there was by clause 4.2 an amendment of it, ends at the point of the STA on the 5th of February 2020. That's what I need you to consider. Now, I'm going to leave this debate here. You can address it and you can formulate your argument. But as I understood what you were just saying then, you are seeming to contend that the MOU obligation survived the STA and that there was a continuing obligation throughout, conditioned by the MOU, to provide 200 kilograms of gold, and he only provided 100 kilograms of gold, which was then substituted, and he did it by a means that was not contemplated by the parties from his own gold resources, but borrowed gold. But of course, there was still 100 kilograms there, so in the company for use, so no loss was sustained in relation to that 100 kilograms. But the loss was sustained by not having the extra 100 kilograms. And that loss continued until February 2023. 5th of February 2020, the point of the STA. But not onwards, because the STA allowed him an extended period to the 31st of December to bring in 100 kilograms of gold. And the issue is whether the MOU obligation survived the STA or whether the STA effected a variation of the MOU obligation. That's what I need you to deal with at an appropriate time and or in your closing submissions.
Much obliged, Your Honor. I will definitely be making submissions in that regard, but I would like to leave one small submission in that regard, that the fact is, even as on 31st December 2020, the defendant has failed to produce 100 kg gold. So it is not in dispute that the business has not received the 100 kg. Business has always suffered the 100 kg shortfall.
Yes, I understand your argument there. And so that takes us to the resolution of the 31st of December 2020. Is that where you were going to go next?
Yes, Your Honor. I would not be going too much into the 31st December resolution in detail, because as I understand, in the beginning of today's session, we have decided that those issues and its impact will be taken up in the other proceeding. So I would be making submissions on the effect of how the 31st December 2020 resolution is to be interpreted. In that regard, my submission would be that the 31st December 2020 resolution acknowledges that there is a continuing failure from the defendant in producing the 100 kg gold. And it also records that the second and the third claimant will provide additional 100 kg of gold in equal ratio from 1st December 2020 to offset the shortfall caused by the defendant.
I want you to take this slowly, because the meaning and intent of the compensation provision here is extremely difficult to discern. So I want you to explain to me how these compensation provisions in this resolution, how you say they work. What is the effect of it? So please take it slowly as you take me through it. So you've said this resolution recognizes the continuing failure to provide the 100 kilograms of gold not provided from the outset of the business operations, right?
Yes, Your Honor. So if I may read out the relevant provision, even the subject of it reads, decision on shortfall to provide 100 kg working capital by Snyder Private Limited.
Yes.
Now, as it makes a reference to the share transfer agreement, and it reads, as on 5th of February, the Snyder Private Limited was unable to cover its obligation to provide 100 kg gold as working capital to the company by the deadline of 31st December 2020.
Yes.
And therefore, it was resolved that Mr. Sami and Rosie's son will provide the company, Sam, with 100 kg gold as working capital in equal ratio from 1st Jan 2020. So the effect is from 2020 Jan.
2021.
Yeah. 2021. Yes. I stand corrected. Apologize. The other two claimants will contribute 100 kg gold, which is an obligation of Shakti.
Yes.
The second paragraph reads, Snyder Private Limited and Mr. Shakti Chauhan will not be eligible for any dividend or fees from Sam Precious for twice the number of days they take to cover their shortfall to bring in 100 kg gold as working capital, starting from 1st Jan 2020. That is very important, Your Honor, because the effect of the board resolution starts only from 1st Jan 2021, whereas the current compensation claim is for the time period starting from 2018 till December 2020.
Yes, I understand that completely. This is a different arrangement. You're suggesting this is a different shareholders agreement to deal with the failure that has now occurred on your case of Snyder to bring in the 100 kilograms of gold that you say is missing.
Yes, Your Honor.
But what I am finding completely impossible to understand is the relationship between the provision that Snyder Prime and Mr. Shakti will not be eligible for any dividend or fees from SAM for twice the number of days they take to cover the shortfall. And then this provision, is there a problem? I thought I heard a voice there. Is everybody hearing me okay?
Yeah, yes, Your Honor.
So then with this provision, Mr. Sammy and Royson will be compensated in equal ratio from the dividend of Snyder Prime Limited, 25% plus 5%, for twice the number of days starting from the 1st of January 2021. Now, how do we get to a figure of compensation? What is the compensation that derives from those two provisions?
Your Honor,
how is the dividend compensation calculated by reference to the number of days, twice the number of days as it's said to be? A dividend is an annual or biannual determination based on the profits available for distribution as a dividend. But this doesn't explain what they will be getting by way of compensation or how it's going to be calculated. Can you explain it to me, please?
Yeah. Your Honor, if I may please suggest, can we take this up in the evidence? Because as I understand from the parties, this was indeed suggested by Mr. Shakti. And there were discussions between them, and perhaps it is better that we take this up in the cross-examination or in the evidence stage, so that parties themselves can come up with an explanation on the background or the reasoning for this. Your Honor, if I may humbly suggest.
I deduce that you must be having the same difficulty as I'm having as working out how this agreement works. So I think it can only be resolved by evidence, but everybody, witnesses included, listening to me, know that I will require an explanation as to what was intended by these provisions here. But at all events, your point is we get to the 31st of December 2020, the 100 kilograms of gold has not been provided pursuant to the STA, and that this arrangement is entered into between the parties in the resolution of the 31st of December. And there, the claim for loss terminates, on your view, on your case at the moment. What else do you want to say about this agreement?
Your Honor, I may have one or two small additional points to be made. I would like to highlight, Your Honor, that how does the numbers look like? In that regard, the defendant has made an investment of 2 million in 2018. And if we factor in the various returns that he has generated out of the claimant number one, it comes up to 17 million in a matter of less than 2 years.
This is the dividends paid to the defendant, you're saying?
Yes, Your Honor. It includes both dividend and settlement of third-party liabilities.
Okay.
The dividend calculation.
So you're saying it's received in total 17 million from its investment of 2 million?
For its investment of 2 million. And
in 2 years.
He continues to be a 25% shareholder of the claimant number one, meaning he continues to earn the benefit of whatever hard work the other two claimants are doing because he is still a 25% shareholder.
Yes. So it's 17 million being dividends.
Dividends and 11 million as per the STA. We saw third-party settlement has been done.
Sorry, dividends how much? You're going to give me the split of figures. Dividends how much?
Yeah. Your Honor, the dividend for 2018-19 is
just give me a total figure. The point you're making here, I presume, is to refute any suggestion of oppressive or unfair treatment, abuse, or anything of that nature.
Yes, Your Honor, and also this is relevant to understand that the defendant has not undergone any prejudice. In fact, the defendant has made substantial gain by investing in claimant number one, but it is the claimant number one who believed in his representation suffered the loss. And the numbers would tell that very simply.
Give me the numbers.
Yeah.
Dividends and payment of third parties.
I only have the breakup for the dividends, Your Honor. If I may please quickly do the calculation. So the dividend for the years 2018 and 19 is a sum of US dollars 746,535.
746,35. Say that again.
535. 746,535.
So 746,000. That's for 2018 and 2019 total.
That's right, Your Honor. And for the dividend of the year 2020, it is 2,000,000.
Yes.
833,592.54. So the total dividend, if we add up 746,535 and 2,833,592.54 is 3,580,127.54.
3,580,127. Yeah.
127.54.
Yes, I have those figures. So that's dividend.
That is dividend. And the obligation of Rosie Sun squared off the benefit of settling his third-party liability by selling off the 25% share in SAM amounted to 14,375,888.
Yes. So the figure then in the STA, just turning it up, of 11,875,888. What has been added to that to get to 14 million? Is that the 2,700,000 that is referred to somewhere being discharged?
Your Honor, there are various board resolutions recording the settlement. I will be taking Your Honor through those amounts.
Very well.
If Your Honor were to refer to paragraph number 5 of the STA, in subclause B, item number 1 and 2, there is a payment of US dollar 710.
Yes.
Will be retained by the company subject to company to effecting payment of the same total amount for a creditor of Snyder, entity A.
Yes.
And in the second paragraph, it talks about an amount of US dollar 2,700,000 for settling an obligation to entity B for Snyder. So if we add up.
Yeah, I'm going to say if you add those two figures to the 11 million mentioned, is that what you get, where you get your 14,375,888?
Yes, Your Honor, I will also do the calculation now.
Do it, please, because I want to be sure about this. I thought these were the figures that you must have been including, but as I said a moment ago, thinking of the 2.7 million.
So the share transfer amount of 11 million.
That is, if you're doing the sums, it's 11,875,888 plus 710,000 plus 2,700,000. What does all that come to?
It is showing an amount which is higher than 14 million. It comes up to 15,243,000. So I'm sure definitely there is some adjustment to it.
Sort it out and advise me in due course when you've calculated the figure that you contend has been the benefit that Mr. Shakti and Snyder have received as a result of its investment, and also its retention, of course, of 25% of the shareholding, though until it produces gold, the resolution of the 31st of December, you say,
is effective from 1st Jan.
From 1st of January, yes, very well. So what you're going to deal with the meaning and effect of the resolution in the course of evidence. And in that respect, I can indicate that I will allow both parties to give their interpretation in chief. Do you understand what I mean? And then be cross-examined on it, because as things stand, there will be no evidence in chief. But this is something which plainly requires evidence from both sides as to what they say was intended by the terms of the resolution of the 31st of December 2020. Is that a convenient moment for a short break? I don't know whether you've finished or what more you've got to do. How long have you got left in your opening submissions? I know it's taken a lot longer, but there's good reasons for that, as I think you would both acknowledge, in the lack of clarity that I've had to explore with you this morning. It will save time later. How long have you got left? If you want to finish, I will let you finish if it's a reasonable time, or if you'd like a break to collect your thoughts and finish shortly after we take that break, then we'll do it that way.
We can have a quick break, Your Honor, and then I will come back to you and I will do a
round up.
Yeah, round up, yes.
Round up. Well, that seems very sensible to me. So it is. It's 1 o'clock there in Dubai, isn't it?
Yes.
Yeah. Yes, Your Honor.
Should we take a short break of 10 minutes now, just to give you time to collect your thoughts, hear you for another however long, and take a break for lunch then before I hear from Mr. Ghosh? Does that suit you both?
Yeah,
yes,
fine with this approach, Your
Honor. Very
Honor.
well. So it's just gone 1 o'clock where you are. We'll resume at 1:15.
Thank you, Your Lordship.
Thank you, Your Honor.
Thank you both very much.
Thank you.
Don't worry at all. All is well. Relax.
Yeah.
We'll have the closing roundup now from you, Mrs. Bijoy, please. Yes.
Yeah. Yes, Your Honor. Thank you very much. So I would like to finally conclude by running the numbers with you, Your Honor, because while we were discussing about the numbers, I was supposed to go and do the working and get back to you. So I have done the correct working and I have the numbers with me. So on dividends, Mr. Shakti has earned USD 746,534 in the years 18 and 19.
534.
And
yes.
Yes, Your Honor. 746,535.
5, yes, I had 5 before. Right. Yes.
And dividend for 20 is 2,833,592.54.
Got those.
That is for the dividend of 2020. That adds up to 3,580,127.54.
Yes.
Now the share premium, as per the sale of the share in the STA, the amount is USD 11 million. 875,888.
That's the figure in the STA, isn't it? Recital.
Yes. That's right, Your Honor. And there is another component in the STA, which is on section clause 6, 1D, which
6(1)(b)
provides for accrued, Your Honor, is on page number bundle.
Yes. 6(1)(b).
Yes, Your Honor, bundle number 92. Yeah, 61D. B.
This is buyback provisions.
Yes, Your Honor, but that records an obligation in terms of the accrued profit from working capital facility.
Ah, that is 6.1D.
1D, yes, Your Honor. Which is US dollars 2,500,000.
Yeah, just let me get these figures down again. So the share premium is 11.
875.
Yes.
888. And accrued profit for working capital arranged by Rosie, which will get set off, is US dollars 2,500,000. So both adding up to 14,375,888.
Yes, those figures all add up to that total figure.
Yes.
But
so the total figure.
This, I just want to be clear about this buyback provision. Snyder to pay 2.5 million being the book value of the accrued profit as at the date of this agreement of the working capital facility provided to the company. Rosie and its designated associates and affiliates will not accrue any further profit on the working capital facility from the date of this agreement. But that obligation to pay is as part of the buyback terms, is it, or is that an independent?
Yes, Your Honor. That has been placed in the buyback provision, but it clearly acknowledges that this is the accrued liability in terms of the working capital facility as on the date of the STA.
Let me just get your position down on that. Clause 6.1D. You say records the liability of Snyder for the
working capital arrangement. Yes.
Yes, Snyder records the liability of Snyder for the book value of the, let me just get this down, for the book value of the
wording used in this clause is
let me finish. Working capital facility provided to the company by Rosie. Is that right?
Yes, Your Honor. I would like to make a small clarification. It's not liability. It is because Snyder is a preferential shareholder in, Mr. Anuj is a preferential shareholder in Snyder Private Limited. For the facility that he arranged, he was promised a return. So what he's saying is, in the buyback provision, it is reflected as if the accrued profit on the working capital facility extended by Mr. Anuj.
So what I've written down in my note is clause 6.1D records the liability of Snyder for the book value of the working capital facility provided by Rosie to the company. Is that correct?
Correct. I mean, for Snyder, it is a liability, but for Anuj, it's a profit.
So what you're saying is that Snyder has had the benefit of that, and it is calculated at that figure of 2.5 million and recorded as at the date of this agreement, the 5th of February 2020, as being worth $2.5 million.
That's correct, Your Honor.
Just pause a moment, because we've lost Mr. Ghosh again, I think. I just saw him disappear. He's back.
Yes. I was trying to rectify the... Yeah, I can hear you, Lordship.
You can hear me? Good, fine, thank you.
Yes.
Good, okay, well, I have your point on that. So what about the debt settled, as it were, in referred to in clause 5.1b, 1 and 2 of the SPA?
Those, I understand, Your Honor, has been factored into in the dividend of 2020, and it is recorded in a board resolution.
Yes, that's right. It is. In June, I think it was July 2020, wasn't it? They've already been dealt with, as it were.
Yes, Your Honor.
Right. Okay. Well, I can forget about those for this particular point you're making of what Mr. Shakti and Snyder's investment in the company has produced for them. That's your point, isn't it?
Yes, Your Honor.
By its investment of 2 million.
Correct. Whereas the claimants did not get the 100 kg gold as promised by the defendants. They had to undergo a lot of, I would say, business loss and other hardships, because it is not easy for anybody who has started off with a big vision to arrange financing to the tune of close to $5 million. So therefore, it is their humble submission that they have suffered a loss of profit and an opportunity by relying on the defendant's promises and by issuing the 50% shares in the company. And this caused significant loss and hardships to the claimants, which they would like to recover from the defendants in the current proceedings.
Yes, well, as we started with, which the first claimant would like to recover from.
Yes, Your Honor, the first claimant would like to recover.
Right, good. Is that you done?
Your Honor, if I have made notes on what the defendant's position is, whereas what is our position. If Your Honor would like, I can quickly run through the positions taken by both parties till now in the current proceeding.
Yes, I'm not going to curtail your opening, but it's 1:30 and there are court staff and your good selves, all of you, who've not had any lunch in Dubai. And this may take a little longer, I suspect, than the 10 minutes we envisaged before lunch, before the break.
Yeah, Your Honor, I would try to wrap it up within 5 to 10 minutes. I would not want to go into the details because I believe we still have 3 days of trial ahead of us, where we have a lot of clarity on many of the disputed facts. So I would like to bring to the court's record the positions that's taken by the parties. As far as the defendant is concerned, they are arguing that the MOU, there is no contractual obligation because the MOU is non-binding.
Yes.
And there is no breach of obligation because it is their position. They have brought in US dollar 9.9 million and gold worth more than 200 kg. It is all in the documentation that they have submitted. It is also their position that Sharjah closure is defective. The board resolution is defective, and that is the reason why they did not approve it. Fourthly, it is their position that the Snyder Private Limited has not received dividends for the year 2020. And finally, they say that the 31st of December resolution is penal in nature and would give wrongful gain to the claimants. And we understand as claimants that the burden is on us, Your Honor, to establish that there is a binding obligation and that has been breached, which has caused a significant financial loss to us. And we will demonstrate this through clear and compelling evidence, the following: that one, there is a contractual obligation. In that regard, we will be making submissions both through witness evidence and supporting documentation that the defendants had clear contractual obligations as per the MOU through the STA, including the obligation to contribute the working capital. In that regard, we would be making submissions on why the obligations in the MOU would continue in the STA, because the parties to the MOU is Mr. Sami and Snyder, whereas in the STA, the parties are the entity claimant number 1 and the other 2 shareholders. There will be a subsequent submission on the breach of obligations, wherein we would try to bring clarity on whether or not the defendant has fulfilled their obligations of bringing in the 100 kg gold by 31st August 2023. Moving on, we will establish that there is a causation and a loss. We would try and establish that the loss that is suffered by the business is directly related to the breaches that are committed by the defendants. And lastly, we would also submit and establish that it is only fair and just that the claimants are adequately compensated for the loss that they have suffered for the additional efforts and resources they had to provide due to the defendant's failure. Now, we are confident that the evidence we will present will satisfy the burden of proof and clearly demonstrate the defendant's actions and omissions have caused us substantial harm. And we respectfully request the court finds in our favor that the claimants finds in the claimant's favor and award the compensation and relief sought. That's all, Your Honor. Thank you very much.
Thank you very much. You were true to your word, very short and succinct there in rounding off. Thank you very much. Mr. Ghosh, I will hear from you. It's 1:30 there now. We'll resume at 2:30 so you can have a proper lunch break. Everybody can have a proper, albeit late, lunch break. And we'll resume at 1:30. We'll review the timetable when you come back. I'll sign off for now. Thank you very much, both.
Good afternoon.
Good afternoon, Mr. Ghosh, Mrs. Bijoy.
Good afternoon, Your Honor.
Is everybody else present? I think they are. Yes, looking at the list on the margin of my screen. There was one thing just before you begin, Mr. Ghosh, that I wanted to ask Mrs. Bijoy, and she reminded me with her last observations about the MOU, if it is binding, being a contract between Mr. Sami himself and Snyder Prime, whereas the share transfer agreement is a contract between the company, Sam Precious Metals, and Rosison and Snyder. So different parties, different contract, you say. And that reminded me of the question that I wanted to ask you, Mrs. Bijoy. The loss that is the foundation of the claim for damages is a loss of profit suffered by the company. The company is not a party to the MOU contract. In all of your references to legal principles in your skeleton argument, you did not refer to any third-party rights under a contract. And I'm just wondering how you put your case on the basis of the party that has suffered the loss, that is the company, which is a claimant, of course, and is a party to the STA. On what basis of entitlement do you say the first claimant, the company, has a right to claim under the contract in the MOU for its loss. Mr. Sammy has suffered no loss.
Your Honor, I would definitely be making elaborate submissions on that in my closing submission, but my short answer to it would be, although the MOU was between Mr. Sami and Snyder, the obligation was towards the company. I mean, the beneficiary of this performance was to be enjoyed by the company or the joint venture entity in which he would form in as a 50% shareholder.
Yes,
So
that's
is
how
the reason.
Sorry, carry on, finish.
Yeah, so that is why we have, from the beginning, we have made all three as a party to the claim because of the peculiar nature of the transaction or the way it has evolved. You have an MOU, you have an share transfer in which the party to the MOU become a party to the company, and then you have a subsequent document in which the company is entering into between the new shareholder.
Yes.
So all across. Yes,
so that's how I understood you must be putting your case. But what you have not referred to is something like, and you'll be aware of this, and I'm not sure whether there's a lot of background noise somewhere, whether there is the equivalent of either in the common law of the DIFC or under its statutory law, something equivalent to the Third Party Rights under Contracts Act, which is a statute in what I might tentatively call the mother jurisdiction of the England and Wales, the common law, and in other common law jurisdictions which have adopted that statutory provision, those statutory provisions. So I'll leave you to deal with it at an appropriate time, but I wanted to raise it with you now because it is something that I will need to be addressed on properly.
Yes, Your Honor, I will be making submissions on that in my closing submissions.
Thank you very much. Thank you. Right, Mr. Ghosh, please.
Yes, Your Lordship. I'll try to keep it very brief because main issue before me is the computation, and for that the evidence has to be led by both the parties, specifically Mr. Sami and Mr. Shakti. But I'll just make some comments on from the legal perspective regarding the MOU as well as the share transfer agreement. The MOU on the face of it is certainly non-binding. If we go to page 185 of the MOU.
Give me an internal page number, if you will, please.
Yeah, I'll give you. Basically, it's a arrangement between Mr. Sami and Snyder.
Yes.
So coming to page 185, the internal page is 6.
Yes, thank you.
No, not page 8. I'm sorry. Which Miss Asha Bijoy has also pointed this out. It is at page 8. It says what is exempted from this binding nature of the MOU. That is confidentiality, costs, and governing law and jurisdiction of the MOU. Now there are many other clauses in the MOU which have not been given effect to. It's quite normal that if somebody wants funding from a third party, in the normal course of proceeding towards it, people do get into an MOU. And once that third party funding comes in and the third person becomes a shareholder, then a new agreement called the shareholders agreement takes place. And also the articles of associations do say that, which is by redaction, it has gone out, and that Snyder Prime Limited became a 50% shareholder. So naturally, the MOU at that point of time doesn't hold good at all. The MOU, apart from being non-binding, loses its effect once the shareholders agreement or the definitive agreements, which is again defined in this MOU, takes effect. But I just believe that most of the definitive agreements have not been executed, which we will understand from the evidence which will be led after this brief submissions from my side. The other legal point, apart from the legal point, we will be able to prove also that even if this was not binding, 200 kg of gold was provided within that period or within that financial year, that is 218. The AFS 200 2018 proves that. As we mentioned,
sorry, Mr. Ghosh, what proves that?
Proves that 200 kg of gold was provided by Snyder Prime Limited in the form of funding from third parties who are not part of the MOU. And later on, yes, Anuj Garg became a party to the STA. The question is, which I understand the opposite counsel has also mentioned, that from where did Snyder Prime Limited get this funding? That is not the issue. Whether Snyder Prime Limited has brought in 200 kg of gold or not is the primary issue according to the MOU, even if it is assuming it's binding. So subsequently, we will prove through the evidence that 200 kg of gold was certainly brought in within the year 2018. Now, in 2020, these parties signed the STA, which is, of course, a contract, which is a binding contract, no doubt about it. What do we see in the STA? Coming to page 96.
Internal page, please.
Yeah. Internal page is 26. And trial bundle page is 96.
No, this number at the center, bottom center of the pages of the STA, please.
10. I'm sorry.
10. There are actually 4 numbers on the document I'm working
Yeah,
from.
exactly.
So we'll stick with the black number in the center of the page, if you all will, please. Thank you.
Yes.
Okay.
Yes, it's 10.
Page 10 I'm looking at. Which clause?
Yes, it's 13.
13, yes.
Yeah. So in terms of paragraph 38 of the claim, it's clearly written that the default committed by Snyder Prime Limited by not bringing in 100 kg gold as per the STA has caused loss to the claimant number 1. Now, default, shareholders default as defined in paragraph 13 clearly specifies what are the defaults in STA. Failure to bring in gold of 100 kg or 200 kg in terms of STA is not a default at all. So legally, this agreement does not provide the claimant any scope or any cause of action is arising out of it, which gives them the right to any form of compensation.
So are you suggesting that clause 13
Yes.
is the exclusive limit of defaults that a party to this contract may commit?
Yes.
So he can commit, on your thesis, a party can commit any breach of any terms of it, but if it's not an event of default, he's not liable. Is that what you're saying?
Yeah, exactly. And coupled with that, I'm also saying that post the resolution of 31st December 2020, that resolution practically summarizes what has to be done as Snyder has failed to bring in 100 kg of gold. So that exactly creates the situation where the parties themselves realize that it is not a default which carries with it a compensation clause in terms of non-provision of gold of 100 kg.
Right, just pause there. Pause there a moment, please. I need to get a note of this. Because none of this is clear from your pleadings or the witness evidence. This is, or indeed your skeleton argument. This is entirely a new submission. You're saying clause 13 provides exclusively.
Yes.
Correct me if I say anything wrong. Provides exclusively for events of default.
Yes. The heading is defaulting shareholder. That clarifies who is a defaulting shareholder. And Snyder Prime Limited is a shareholder in this agreement.
Events of default by a shareholder. So that you are saying no other breach of the STA will give rise to Is that your position?
Yes, that's my position within the ambit of this agreement.
That's a radical proposition, Mr. Ghosh, I must say to you immediately.
Yes, Your Lordship, but in coupled with, as I mentioned, 2020 board resolution clarifies what is to be done, what has to be done, as Snyder Prime has failed to bring in 100 kg of gold, which includes obviously not paying them dividends since 2020.
So you say resolution of 13th of the 12th.
Yes.
20 demonstrates what needed to be done to provide a remedy for a breach of the agreement. Is that the STA of this? Of
Specifically,
the
not providing 100 kg of gold. That's the case of the claimant, and
okay.
2020 December resolution speaks of that. What is to be done, as Snyder Prime Limited has failed to bring in 100 kg of gold in terms of the STA. They didn't mention any other default or whatever. It was specified to only to the gold issue.
That is in the resolution. It doesn't mention any other default, you're saying?
Yes.
Right. Well, I want to read this note back to you so that I understand precisely what your case is. You say clause 13 provides exclusively for events of default by a shareholder so that no other breach of the share transfer agreement will give rise to a claim for damages against any shareholder. And further, you say the resolution of the 13th of December 2020 demonstrates what needed to be done to provide a remedy for a breach of the STA by not providing 100 kilograms of gold, as evidenced further by the fact that they have not mentioned any other default in that resolution.
Yes, and the most important part is in that December resolution, they have specifically mentioned that because Snyder has failed to provide that 100 kg of gold, we will not be providing Snyder the profits or the dividends from of the subsequent years, and that's still continuing. So it's a continuous cause of action which has given rise to the other two cases. I'm not going into those details because that's not the issue here. But most importantly, from 2021, the dividends have not been provided. They are, Mr. Sammy being the 50% shareholder of claimant number 1 and claimant number 3, the other 25% shareholder, they have been enjoying all the profits by themselves since 2021.
Right.
That figures.
We're not going there, as you just rightly said, but this is the important essence of your submission that I have just noted and read back to you, and you confirm that is a correct rendition of the submission that you are making in this case.
Yes, yes, Your Lordship.
So that there is, as a result, you say there is no liability for damages on the part of Snyder Prime for failing to bring into the company the 100 kilograms of gold that is complained of, right?
Yes,
okay.
Yes.
I have that submission.
The third submission, if it is found ultimately that yes, there has been a default on the part of Snyder to bring in 100 kg of gold post the STA, if Your Lordship comes to a conclusion on that, then they will be only entitled to a compensation from the date of the STA till 31st December 2020. If it is found also from the evidences that whatever money or whatever dividends they were supposed to pay Snyder Prime Limited post 2020 are not covering that amount, which is the loss amount. So there will be a clear case of set off.
I'm sorry, Mr. Ghosh, that is a legal proposition that is very difficult to follow. Are you saying that the dividends that were not provided to the shareholders should be set off against the company's claim for damages for breach of contract?
That's the purpose of the resolution, December resolution only. That is why that's such a harsh penalty has been imposed on Snyder Prime Limited, that you will not get any dividends post since 2021.
So again, let me get this proposition that you're making correct. If it is found that there is a default, well, really you mean a breach, because I'm asked to find if there's a breach or not. If it is found there is a default or breach of contract, then the dividends not paid to the dividends not paid by claimant number one, the company,
yes,
to Snyder should be set off against the company's claim for damages. That's your position?
Yes.
Very well. I have that submission carefully noted.
So going now, I'll not proceed further except the Sharjah refinery issue. And in the Sharjah case, obviously the board resolution, we have challenged the board resolution, and there is no prayer in the claim petition asking a declaratory relief that the board resolution was perfect or there has been a breach committed by Snyder Prime Limited in not signing the board resolution. So there is no declaration or no prayer for declaratory relief that the board or the sign that there has been a breach committed by Snyder Prime Limited with respect to not attending the shareholder board meeting and signing the resolution. And the compensation which they have asking, that has not been also computed.
So no prayer for declaratory relief that Snyder Prime has failed in any obligation to sign the board resolution. Well, it's the board resolution or a shareholders resolution?
I think it was a shareholders resolution. I'll have to check that.
So that is your well, that and the fact that the loss has not been computed. That is your answer to the claim, the second, the claim. I'll call it the Sharjah claim for convenience.
And of course, through the evidence, I believe we will be able to substantiate that we were not allowed into the meetings, the board resolution and wherever these meetings were held and passed. Those were the grounds based on which the two other cases were filed. And most of the documents have been redacted, so some of the documents are not here. But that is one of the pleadings which we had earlier. So
that is definitely in CFI 019.
Yes,
a suggestion that you weren't allowed into meetings, but your defence to the Sharjah claim in these proceedings, you've just articulated it, that there is no prayer for declaratory relief that Snyder Prime has failed in any obligation to sign the shareholders' resolution, and secondly, that the loss has not been computed.
Yes, and yes, correct. I agree with you. And in the preliminary submissions, also it has been mentioned that there has been a unanimous approval in proceeding with the Sharjah refinery case, and what is unanimous, that's a question which will come out through evidence, because we were not part of that meeting.
Very well. So we have to wait for the evidence on that to see whether
Yes.
that was a unanimous agreement of the shareholders by their accredited representatives to close the Sharjah branch.
Yes, yes.
Very well. We'll wait for the evidence on that then.
So in a nutshell, the closing submission is we are not liable to pay any compensation to the claimant number 1.
Very well.
That's all, Your Lordship.
Thank you very much. That's very brief. And I've taken, as you've heard, a very careful note of what your positions are on all of these issues. And we will wait for the evidence on whether the resolution was unanimous or not. You have in the pleadings, you have contended that this is a shareholders reserved issue under Schedule 1 of the STA.
Yes, yes.
Do you accept that if I find on the evidence that there was a unanimous vote of the shareholders to close the Sharjah branch, that you are in that the shareholder has caused loss to the company, apart from it not being computed, by reason of its failure to cooperate in signing?
No. We had raised an issue regarding the shareholders resolution, saying that the agenda is not properly drafted, it's not circulated. These are the reasons which we have shown while not cooperating with this resolution, basically.
I understand. So it wasn't a proper resolution
Yes.
to be acted upon.
Yes, and the main witness, that point of time, the main person who was working on that, he's now a witness for the claimant, unfortunately.
This is Dino, who we were referring to before.
Yes.
Very well. I think then on that basis, we can proceed with the evidence.
Yes, Your Lordship.
Now, as I indicated earlier, I will allow short evidence in chief on the resolution of the 31st of December 2020, apart from the normal introductions and proof of the statements, which you'll give me the page references for in a minute. Is there anything else that you, Mrs. Bejoy, seek permission to lead evidence on in chief?
Your Honor, apart from the December board resolution, if I could also have one or two questions on, especially the bringing of the 100 kg gold and the involvement of Al-Asil, because we do not have any documents in this bundle otherwise to substantiate that. If Your Honor may please allow, I would like to have a direct question on that from the witness.
Mr. Ghosh, do you object to that?
Yes, of course.
You allow
that?
Very
important. Yeah.
Very well. You will, of course, be allowed to cross-examine about that as you see fit. Yes, then, Mrs. Bejoy, I will give you permission for those two matters to be dealt with in direct examination, as the Americans prefer to put evidence in chief.
Yes.
So now we're hearing evidence, and the other witnesses for the claimant should not be present or listening to this evidence, certainly not the cross-examination. So you're going to call your first witness now, Mr. Sami, I presume?
Yes, Your Honor.
Just remind me of the page number in the bundle of his first statement.
Yes, that's on page number 336, Your Honor.
Thank you very much. Very well. You may call him. Is he going to take an oath or affirm? I can't hear him.
Sami, you're on mute.
Sorry, I don't know the procedure. Good afternoon, Your Honor. Good afternoon, everybody.
Now we have Ms. Kwali online as well and visible. Good afternoon to you both, newly visible on our screens. Do you wish to take an oath or affirm before you give your evidence, Mr. Sami?
Both is okay for.
Okay.
You would be sorry to interfere,
Yes.
Your Honor. He would be going for the secular oath. I'm not sure whether he has the holy book with him.
Very well.
Actually, I have in my office. I can bring if that is faster. But if there is other option, also I have no problem. Whatever easier.
Well, it's your choice, Mr.
So, like
Sami.
what Miss Aisha said, like what Mrs. Aisha said, yes.
So you want to simply affirm, do you?
Yes.
Very well. Can you, Lena, please administer the oath and follow the instructions you're now going to be given by Ms. Kwali?
Thank you, Your Honor. Can you please confirm your name and occupation for the court's record, please?
And sorry if I interrupt. For me, for bundle, I have here Mr. Saadi just to help me for taking the bundle from the bundle and allow me just to access for it because I have one screen and for technology and other things, I saw the bundle is too big. I
So
have only with me.
Who is
allowed. Mr. Saadi.
Mr. Saad.
Saadi Ahmed.
He's not a witness in the case.
No, not witness in the case. If you allow me, he only will assist me for taking whatever things from the bundle.
Yes, well, I would allow the same assistance from a non-witness to any of Mr. Ghosh's witnesses in due course. I think that will smooth
Yes.
proceedings. So thank you for letting me know that. And I will say that all other witnesses should let me know if there's anybody else in the room with them when they're giving their evidence and especially being cross-examined. So, Ms. Kwali, can you resume, please? And Mr. Sami, just please listen to Ms. Kwali now.
Thank you, Your Honor. Can you please confirm your name and occupation for the court's record, please?
My name is Sami Riyad Mahmoud Abu Ahmed. I am the chairman of some Precious Metal.
Thank you. Can you please repeat after me? I affirm that I will say nothing but the truth.
I am, again, please.
I affirm
I affirm
that I will say nothing
I will say nothing
but the truth.
but the truth.
Thank you, Your Honor.
Thank you very much. Right, so you are affirmed and ready to give your evidence. You're going to be asked a few short questions, first by Mrs. Bejoy, and then you will be cross-examined by Mr. Ghosh.
Your Honor, by way of housekeeping, before I start, I understand that Mr. Sami's native language is not English. So Mr. Sami has put in a request for me to go a little slow so that he understands the question and then be helpful to answer my questions. So I believe if the same courtesy can I be requested from the opposite counsel when he raises the cross, we would be really grateful for that.
Yani,
Yeah,
Your
sure.
Honor, only in a few words if I need a clarification, but definitely I'll do my best to not delay your procedure.
Very well, thank you, Mr. Sami. I'm sure Mr. Ghosh will afford you the courtesies that Mrs. Bejoy will afford to his witnesses in case there's any similar difficulty. We're here to do our best to get to the truth of these matters, and we will make sure that all witnesses give their evidence as comfortably and as comprehensively as they can. So do not be stressed or troubled. The court understands that giving evidence is not an easy task. Just listen to the questions. They'll be phrased slowly and carefully, and answer the questions. Don't go off onto a speech of your own. Just answer the questions you are asked. and then we will get through it much more quickly. Good. So, Mrs. Bijoy, as you wish.
Thank you very much, Your Honor. Mr. Sami, you have submitted 3 witness statements in this case. However, for the purposes of the current trial, we would be relying on only 2 witness statements. The first witness statement is found on page number 336 of the bundle. Can you please locate page number 336 on the bundle, please?
Yes. Yes.
This is your first witness statement. Can I please ask you to confirm your full name and address as reflected in the witness statement for the court's record, please?
My name is Sami Riyad Mahmoud Abu Ahmed. I'm a businessman by profession, accommodating at Thanaya 5th premises, number 393-291-596, PO Box 283648, Dubai, United Arab Emirates.
Thank you. Could you now go to the last page of your witness statement, which you will find on page number 354 of the bundle?
Yes, it is my signature.
Okay. Do you confirm that that is your signature?
Yes.
Thank you. Do you also confirm that the facts stated in the witness statement are true to the best of your knowledge and belief?
Yes, I confirm.
Thank you. Could I now request you to go to page number 393 of the bundle?
Yes.
You confirm that this is your second witness statement?
Yes.
And if you may please go to page number 401 of the bundle. Do you confirm that this is your signature?
Yes, I confirm.
And do you also confirm that the facts or the contents contained in the second witness statement is also true to the best of your knowledge and belief?
Yes, I confirm.
Thank you. Can I now take you to page number 24, sorry, page number 340 of the bundle?
Okay. I'm on it.
Okay.
Yes.
And you have stated that in that paragraph, in paragraph number 14, that the 100 kg gold,
Yes,
was brought on September 2018.
Second, you say 14, excuse me.
Paragraph number 14.
14. 14, I have here. I
On
stated
page number
that
340. You can go through the paragraph and tell me.
340, I said that deposit several assurance and promises. First evident failed to provide first claimant with any of the 200 kg of gold till September 2018 in a breach of their obligation. In September 2018, the first dividend provide the first claimant with 100 kg of gold, which 50% lesser than their agreed commitment of providing yes.
Yeah, may I please hold you there?
Yeah, here, yes, here 50 of the claimant I mentioned here, yes, that 50 lesser than their commitment of providing first claimant with the 200 kg. And the bulk 100 kg gold was arranged in the form of a loan. Yes, please. Did I answer you? From the third party. Yeah.
Yes, Mr. Sami. So the point that I wanted to clarify with you is the date on which you received gold? Because in your statement, you said you received the gold on September 2018. However,
Correct.
if you refer to paragraph numbers 25 and 26 of the particulars of claim, okay, which is on page number 24 of the bundle.
Paragraph
25 and 26.
Okay.
It talks about,
there
appears to be a discrepancy because in 25
Correct.
and 26, it refers to 50 kg of gold. Now, can you explain to the court, when did you actually receive the 100 kg gold?
The 100 kg received on 15 September 2018. And this is wrong. The point that is, it's all of that is reflected in our financial statement 2018 as facing 4.9. As well also, okay, thank you.
So, Mrs. Bijoy, this paragraph 25 of the particulars of claim is wrong.
Yes, Your Honor. So we wanted to clarify this through the witness so that we can get the facts right.
So Sam received 100 kilograms in September 2018.
Correct, Your Honor.
Yes. And it's referred to, as we were looking at before, the inappropriately, it's described as a loan. It doesn't refer to it as a gold loan.
Yes.
With your permission, Your Honor, if I may have one or two direct questions on that, perhaps the witness can give you more clarification.
Very well.
Mr. Sami, thank you very much, Your Honor. Can you explain to this court, how did you receive this 100 kg gold in September 2018?
This is in terms from the third parties. They have already associated companies, but they brought it in dollar. Today for gold business, my condition on MOU to bring physical gold 4.9. For me, easy to allocate the physical gold as investment where I can use in my business. The point they bring it in currency. At that time, the gold 100 kg less than this amount, but because they didn't bring physical, we put a margin account, we call it in the trade, to protect that 100 kg. We are going to use it for buying and selling and other things. So we agree together as a shareholder, the 4.9 facing the 100 kg of the gold. If he brought to me 100 kg as is, no need to take any extra amount. I will take 100 kg, end of the 5 years, I will give him the 100 kg. My obligation with him, 200 kg. But he brought only 100 kg. Yes.
Who did you receive this 100 kg from?
It's a third party. Honestly, I couldn't, but it is mostly as Al-Asil, because, you know, the SPL, they have a lot of companies, they are taking, doing business with us, normal customer. As well, also, he used them for the investment account. So here I need to differentiate. There is something we call it customer account, which people buying, selling, refining. Other account, which is the investment, which is never come more than 4.9 for it, for the 100 kg as the half of his commitment since beginning of the relation, as I heard also. Everybody
stop there. Sorry. Stop there, please, while I get a note of that.
Yes.
So this 100 kilograms you received from Al Azil, and this is placed in an investment account, which is differentiated from a customer trading account.
100%.
Just pause. And when it's in a customer trading account, it is there for the purposes of a margin. Do I understand that correct?
If the gold came as a physical 100 kg, there is no need margin. No. But because he brought to me in currency, gold fluctuation moving ups and down. So like this, we are taking a little more money, and we agree that money to face total 4.9. The 100 kg facing 4.9. My condition if to bring 100 kg, but we agree because to protect the fluctuation of gold, he has to keep the margin extra, and we agree that time it's for the year 2018 and 2019. The range of gold is 4.3, 4.6, 4.7. We agree to face that year at 4.9.
Did you?
Yes.
I'm sorry, I'm not understanding this.
No problem.
Did you actually receive 100 kilograms of physical gold from Al Azil in discharge, partial discharge of the defendant's obligation to provide you with 200 kilograms of gold? Did you get 100 kilograms of physical gold?
I received a value of currency of 100 kg. Not 100 kg gold.
But you regarded that as sufficient provision of the 100 kilograms. Just let me get a note of that. And it's that figure of 4.9 that includes a margin to provide for fluctuations in the price of gold over the course of the year. Is that correct?
Correct.
Pause. Well, Miss B. Joy, this explains the entry in the accounts. It wasn't gold, it was currency in lieu of the 100 kilograms of gold with a margin to protect SAM against currency price fluctuation. Gold price fluctuation. That's correct, is it?
Yes.
Yes, Your Honor.
Very well. Your next question.
Now, moving on, Mr. Sami. I believe the 100 kg was to be used for working capital, and the operation was expected to commence on the 1st of June 2018. Can you clarify as to when exactly the first claimant company started its operations?
First kilo came to the market is 15 May 2018, first production. During that, we purchased a Sharjah refinery, 100% subsidiary for SAM, Precious Metals FZ-LLC. So this is the point where we started the production on 15th of May, 2018.
15th. You say in your statement.
Sorry, 15th of May. Yes.
15th of May.
Correct.
2018. The first bar of gold came out of Sharjah. Is that right?
Right.
This is in the statement, Mrs. B. Joy. This is not. It's not necessary for you to elicit that evidence.
Your Honor, there is some confusion on the date of commencement of the operations. That is why I wanted to clarify this. I understand that it is already there in the statement, but I was thinking that there is a lack of clarity because of some other descriptions elsewhere. But
all right, but we have the evidence now clearly that yes. The 15th of May 2018, the first bar of gold for SAM's production came out of the Sharjah facility. Is that right?
Yes, Your Honor.
Very well. That's the evidence.
Now, moving on, Mr. Sami, can you please refer to paragraph number 10 on page 18 of the particulars of claim? Which is on bundle page
Here,
reference.
yes, here, yes, please. You want me
Bundle
to read
page
it?
number 18 of the 18.
Yes.
And para 10.
Yes. Para 10
is
only. Yes.
Para 10 only. It is
Yes.
stated that the license of the first claimant was granted by the Dubai Development Authority on 13 March.
It is
Can you
12th of
clarify
March.
what date the license was issued?
12th of March.
12th of March.
12th of March, yes.
I've made that correction.
Yes, Your Honor, that's again another correction in the particulars of claim. We would now like to move on to paragraph number 16 of your first witness statement. This is on page number 340 of the bundle. Are you on page number 340?
Yes,
Mr.
yes.
Sami?
Yes,
Yeah.
yes.
I'm reading out the first sentence, which reads, I state that the third defendant owed AED 11,875,888 to Mr. Anuj Garg. Can you confirm if the figure is correct?
The figure correct, only currency need to change to dollar, please.
Okay, so it's not...
Not dirham, it is in dollar.
Okay.
Sorry, what's incorrect? The defendant provided the claimant with 100 kilograms of gold. It wasn't gold, it was currency representing 100 kilograms of gold with a margin. That's how I've understood the evidence so far.
No, sir,
No,
we are
no,
talking. Yes.
This is on a clarification, a clerical correction on the denomination of the currency, which is on paragraph number 16, Your Honor, of the
16.
Mr. Sami's witness statement. Yes, 16.
Page 340.
Yes. Right, sorry. I think you did say paragraph 12. Doesn't matter. That's USD.
USD.
Correct.
Exactly.
16 correction. Yes. I've made that correction.
Thank you, Your Honor. Mr. Sami, could we now move on to paragraph number 39 of your first witness statement?
39.
Which is on page number 395. Sorry, 348. Sorry, I stand corrected. The last line of that paragraph, it is written where defendant number 1 has signed a lease and applied for approvals to commence the renovation work in the new warehouse.
No, here a claimant number 1. I am, yeah, the company says.
So it is again a correction. It is not the claimant. It is not the defendant. It is a claimant.
Correct.
Number 1.
Yes, I've made that correction.
Now, can we move on to paragraph number 8 of your second witness statement on page number 395?
Okay, I'm on it.
It is stated that the first defendant contributed $1.041 million as per the audited financials of the first claimant for the years 2018 and 2019. What was this contribution for?
Actually, this is a loan. I'll explain it in two ways, but it gives some meaning. This is loan Snyder Prime give it to Sam to protect the position of his affiliated company's position from trade. Usually, traditionally, we are doing here. If customer, he work with his associate always we look for his position by consolidated all accounts together. So because he is a shareholder, as well also bring the affiliates, we kept this situation like this to protect his other trading accounts. So the other associated company bring gold, refine it with us. Either they take gold or they sell it. So always he has a position with us. This position protected always from the margin account he left with us for them. And by the way, sometimes this one we are crediting more, sometimes we are less. And in STA, if you observe, and I during your you explain it, STA at that point we found when we make the clearing of his account to go ahead with STA, we found that it's only credit 291,000. Sometimes it goes up, sometimes we credit them based on the position and market movement. So this is not the investment totally. This is only related to his trade and his associated company and affiliated.
Related to Snyder's trade.
Yes.
And
yes.
And the trades of its associates.
Exactly, Your Honor, yes.
And it goes up and down, so that when you came to, as it were, clear the account at the time of the STA, it was found that there was a credit due of 247 or whatever the figure is.
And yes, sorry.
But at the same time, you settled a liability of one of his affiliates for 700,000 in the STA.
In the STA, we are settled entity B, which is $2,700,000 from his. We advance his dividend.
No, I'm referring to clause 4.2 of the STA, where you refer to this figure we're talking about, 1.041 million.
Yes. Yes.
And this you've described as a protection, yes. a deposit to protect the trading position with Snyder and its associates.
Exactly.
And here at this juncture, you are clearing that. And the way of clearing it is to pay back to Snyder $291,711 US, and to use $750,000 to discharge one of your company's debts payable by a Snyder affiliate.
Yes,
I'm understanding it.
Yeah, thank you, sir. Thank you, Your Honor. On the other hand, we credit his entities. Yes, so that we offset both of them. Only payable for him at that time. At that moment, 291,000.
Yes.
Okay, Mr. Sami, can we now look at the 31st December 2020 board resolution, which is on page number 105 of the bundle?
Yes. I'm on it.
Can you please tell this court, what does this board resolution mean?
Sure. Actually, this is text. I try to short it maximum, because my story with the Snyder, it's really needs to talk a lot, but I'll try maximum.
Mr. Sami, if you want to give a little bit of background is also fine, because court would want to find out the real truth. That's why we are here. So on the board resolution.
Let's see, and if I want to give, if your honor allow me, I'll try maximum 2-3 minutes to build the things how it came like this. Since beginning, my project this time, it's some precious metal. It's a new concept. This a new concept after 3 success story of my life. I tried to make something is not existing in our region. So that's why the concept, I can handle it and do, but I tried to look for a partner to expedite how to achieve my business plan, which is 10-year opening 13 branches, connecting producing countries with consuming countries. As well, also, there is a lot of challenges how this business plan will study, and why from beginning I refuse to open my door to any investor till I establish my company. So I didn't, since day one, I left my ex-employee. I calls not to stop because people really wants to shake hand, wants to invest, because bullion market get more recognition as important business for the future.
Mr. Sami, if I may, sorry, with your permission, Your Honor, if I may interfere, you can focus on the board resolution and the related facts.
Very fast.
I think that's
very
where
fast.
we are.
Okay, very fast. That is a brand. You see, if we want to look from MOU, he should bring 200 kg. He couldn't bring it, and instead only bring half of it. And by end of 2019, I got the news from him. He is obliged lender. They need from him money, and I was shocked at the time. I'm waiting the 100 kg. I found him to tell me how to come over of this problem. We signed STA. Now in STA, he brought to me new partner, and in the new partner, we go there. I represent my board completely with STA to focus on all details there in the STA to make sure that is what is agreement between them, at the same time to ensure a new investor well aware about the condition in MOU for 200 kg. Now, the 50% was to bring 200 kg. I dilute my share for 50% to bring 200 kg, or the partner should bring 200. Now it became 25-25. So they agree that SPL is still, they need to bring the 100 kg, and a new partner, he come and bring 100 kg. Now, during this time, he is requested to put on time till end of the year, or till 30 December, end of the year for 2020. Just, he's sure he will bring it faster, but he said aloud. Now, as in good faith and promising that if things will come earlier, we give him that, but following up closely with him till we reach for 30. In 30 alone, I don't want to go for details how it happens, but midnight he came to me and come and say, Sami, if you can put it, and I do want dividend. Anyhow, I told him, now there is a new shareholder. Let's meet. We listen to your offer. We come out. We come with this offer. Now, for the coming period, from 1st January 2021 onward, he's not taking his dividend. He receive it, but give it to us if we are going and deploy this obligation from him. And we did this, and we found it in good faith also. He will bring it because he promised 16 January 2021 he will bring his 100 kg. And if he brought for me a paper, show it to me that there is my fund take off, blah blah blah, and they show me that 50 kg will hit 16 January, and before March he will bring. Nothing came. What happened? You see now we accept to sign that paper, which is I believe it's bleeding for us, because his asset continue increase, became non-contribute at all with his partner, and two board meeting, two shareholder meeting. I disagree with Mr. Shantanu. That is there. We call him and we for the two shareholder meeting for closure of Sharjah, where we shocked in the before second meeting, that is he transferred his share to his wife without notifying anybody.
I've got to stop you there. We are trying to understand the actual terms of this meeting, of this resolution, of the 31st of December. So can you have it open before you, the document, the minute? Get your colleague there to give you the minute. because that is what I've allowed evidence to be given on. I have not interfered. I've given you a lot more leeway than you're entitled to, but I want to have an understanding of what this agreement means. I understand all of the background. You've just gone through it again. It is in your evidence that because he had not produced the 100 kilograms of gold by the 31st of December 2020, you came up with this agreement whereby you and Rosie's son, you and Royce's son would meet his obligation to put 100 kilograms of gold working capital into the business. Now, I understand that at this date. What I don't understand is what the clauses mean in terms of the compensation provisions, whereby he would not get his dividend. So what I want you to focus on is clause 1. It's got a number 1 before it, then a small 1, which is you and Rosie's son, Rosie will call it, providing the 100 kilograms of gold he still could not provide as at the end of 2020. That is clear. Item 1. Item 2, Snyder Prime Limited and Shakti Chauhan will not be eligible for any dividend or fees from SAM Precious Metals. And it's this bit I don't understand. For twice the number of days they take to cover their shortfall to bring in 100 kilograms gold as working capital starting 1st January 2020 and set to expire 31st of August 2023. That is the 5-year period.
Sure.
And then this, Mr. Sami and Rosie will be compensated in equal ratio from the dividend of Snyder Prime Limited, 25% plus 5%, for twice the number of days starting from the 1st of January, which Snyder Prime Limited takes to replace the working capital goal obligation temporarily fulfilled by you and Rosie. Now, how do the figures work? What does it actually mean in terms of what you will be receiving?
Sure. Now, from 1st January, if the gold any day will go, we are going to calculate that day dividend plus 1 day in advance. Why this calculation coming? We are in golding business, could be that loss and the profit. So now when we are putting and cover his obligation, that there is this offer calculated also behind it, there is some mathematics is done also in the presence of defendant 3 as well also claimant 3. They come and reach, this is the best and fair deal. That is the 1 day equivalent to 1 day, because if there is losses, so we are carry losses. So we said each day of dividend, he didn't bring, this day is calculated plus 1 day extra front because of his obligation. Example, if he brought the gold on 5th of January. So on 5th of January, from 1st January till 10 January, he's not entitled for a profit.
But you've got to have, are you suggesting that you will look at the date when you come to calculate the dividend, and I understand you did it half yearly, you would come and calculate your dividend in, let's say, June, and if he had not provided the gold in the 5 days example you're giving, what are you doing? Are you apportioning the dividend over the whole 6-month period and reducing it to a daily amount so as to deny him a dividend share for 10 days, twice the number of days, using your example?
Your Honor, we are talking about look period. we are talking about providing capital for 5 years.
Yes.
Today, now, balance of 5 years ended by August 2023. So we are now, if this obligation, if it is not filled for all of that, all the risk taking and all the effort done by another shareholder, and the other one is not contribute anything. The concept came from like this. Otherwise, we could at that time, we are going we couldn't continue for non-contribute partner. This is the concept how we built it. We try to make
I understand, Mr.
Yes.
Sami, I understand that you were going to have some compensation for the fact that you were carrying Snyder Prime's obligations, but you are not explaining to me what the practical effect of this agreement is, what it means in terms of how the amount of dividend that is not paid to Snyder Prime is paid to you, how it is calculated. This is incomprehensible to me as it stands, and you have got to explain it to me, what it means in practical terms. And that is why I've allowed Mrs. Bejoy to ask you the questions, but she's not asking it directly, as I need to have an answer.
Correct. So
tell me how it is calculated, your entitlement, and how it relates to these words that we're looking at.
Okay, as you now, for mathematics and other things, of course, I have more technical people better than me to make the mathematics simple, especially also Snyder ex-directors, as well also Mr. Anuj. But I will try to simplify to make you on with the environment. Assume we gain end of the year 1 million. Snyder entitled, first of all, the consultancy 10% will go up. There is a 900,000 balance, correct?
Yes.
Yeah. So
now take this slowly, because this is exactly what I want from you.
Sure.
All right. So you start. We're using an example. You've got there's a 1 million profit.
Yes.
To be shared out as dividends at the end of the year. Okay.
Yeah.
That's the starting point. Now you tell me, because
there is, excuse me, Your Honor, there is,
yeah.
I have board here. If you want, I can write it and show it to all, or if you, as you like, or you want
I think
me to continue.
we might have to resort to that, but I think we're getting there now.
So,
and then you say there's 10% to be deducted from that.
The consultancy. So there is
the consultancy. So the consultancy reduces the funds available for distribution as dividend to 900.
Yeah.
Right, 900,000. So
yes.
So that then you've got 900,000 for the year.
Yeah.
And are you saying to me that you divide that by 365 to get to a daily dividend? Is that right?
Yes. Sorry, I lost little. Now 900.
Yes.
50% it will go for me.
Yes.
225 it will go to SPL. 225 to Rosie Sun. The 225 as per we don't know. Yeah, this one again it will split. 12.5 for 50% for Sami, 50% to Rosie Sun. So again,
yes, but that I understand that is for the year, but to get to a daily amount, you've got to divide the dividend due over the 365 days of the year.
Till if any day he bring it till end of lockdown period. Lockdown period, it's 8 August 2023. From the MOU, the 200 kg from beginning MOU should be lockdown period for 5 years.
Yes.
So today, assume after 6 months, he brought his 100 kg. Assume he fought from 1st January till 30 January 2021. So up to end of 2021, he is not eligible for a profit. His profit will start from 1st January 2022.
When he brings the gold in.
Exactly.
All right. So
now,
remember,
can
stop a minute. Remember, I am trying to interpret this clause. And you talk here about shall not be entitled to dividend or fees for twice the number of days they take to cover the shortfall of 100 kilograms. Now, in order to put that in monetary terms, don't I have to work out from the end of year dividend figure? We're using an example of 1 million less 10%, and 225,000 of it due as the 25% shareholding of Snyder. Don't I have to divide that 225,000 by 365 days to get to a daily dividend, which he is not going to get?
It's a difficult, Your Honor. You are much better than me in technical, but I prefer Mr. Anuj to explain it to you because he's in handling this matter, who's, I believe, his witness after me, technically and mathematics. Also, I have a big team of accountant and CFO, but unfortunately, they are not witness. So they will show you the whole mathematics. But my capacity of mathematics, not like, mashallah, your honor.
All right. I accept that, Mr. Sami, that you are not the best person to explain this to me. But I've got to ask Mrs. Bejoy, do you understand the difficulty I am facing at the moment? This is meaningless without implication of various things, and it may be so uncertain as to be unenforceable. So you've got to demonstrate to me what it actually means and how it would be understood by reasonable businessmen in the gold trade before I can give effect to it, or describe, as the issue is, what its effect is. Do you see what I mean?
Yes,
And
Your Honor.
You understand the difficulty. There's no point in asking this witness any more about it. He is not able to explain it to me. He's just said so himself.
Yeah, I absolutely follow you, Your Honor. And we have subsequent witnesses who will be addressing you appropriately with much more clarity. And I'm sure definitely Your Honor will have clarity after their witness examinations. In fact, Mr. Sami is a technical person and he's not involved in numbers and calculations. And I understand that is a difficulty. So ideally, we should be placing these questions with the other witnesses, which I'm confident that would bring in clarity that Your Honor is seeking for.
Well, Mrs. Bejoy, this was your choice of witness to explain this to me. And so far, and this is no disrespect to you, Mr. Sami, I accept there are technical wizards and accounting wizards, and you are the former and not the latter. I accept that. So unfortunately, you were the wrong witness chosen by your counsel for this purpose. I'm not going to trouble you any further. That is the limit of your permission expired, Mrs. Bejoy, for examination in chief. And I will now turn to cross-examination.
Yeah.
Yes.
That's all, Your Honor. I'm done. Now the witness is ready for cross-examination.
Only I want to add in a trading.
Mr. Sami,
well, if it's to clarify something he said,
I want to say in the trading how I'm doing my management. The concept that is, this is what we agree on it, and we are following. Of course, from legal perspective, I do understand your honor, your points. That's why I said I have board of directors. They can show you how is day and plus 1 day. My side, as a bulk, as I explained to you, this 100 kg came. The profit example from this date plus another 1 day, that day in the future coming, is still not coming.
I understand. I understand that part of it, yeah. But the mathematics need to be explained, which are implied in these words here, for there must be some mathematical process whereby a figure is arrived at, and you haven't been able to explain that to me, and I will wait for the witness who can explain it to me in due course. Sure. And Mr. Ghosh, you may now cross-examine, but I suggest that it is better for you to wait for the interpretation of this resolution to the witness who we are promised will be able to explain its meaning. But yes, please do cross-examine on the matters that you wish to raise.
Yes. Good afternoon, Mr. Sami.
Good afternoon.
Yes. This case you have filed in the month of April 2023. I can understand from the particulars of claim. So before that, 2 more cases were filed by Snyder Prime Limited against you. So before asking you a question, I would suggest that this is a counterblast to those 2 cases. 1 year, 5 months, you have been sitting idle without filing a case against Snyder Prime Limited for the damages. What's the reason?
See, actually, that is not true. Already we go for Dubai called for amicable, which is his owner, and dismiss it. And we go to bring a third party between us, amicably, to find a solution to meet unknown person. We couldn't see him, invisible, but we couldn't reach him. So once we get the expert report, and we saw that is after meeting them and meeting us, no way, we go to the jurisdiction to raise our problem. So if you look for time after factor, when we got the expert report, when we submit, you can understand who start this one, Mr. Shantanu.
You said something invisible. I didn't understand, actually.
The case in Dubai court.
Yeah.
The case in Dubai court. There is expert report which his owner refused to look for it, or he's not accepted.
Yeah, because it's DIFC jurisdiction is the governing, yeah. I mean, dispute resolution clause.
At the time, we are moving. At that time, we are approaching for the expert to evaluate the damage and understand. Jurisdiction for us important, but if we go to the DIFC, it's longer procedure. We need to go for faster procedure to bring him to the table and discuss with him all the point why he's doing like this.
Okay. Okay, let us come to your witness statement, paragraph 6. It is at page 338 of the bundle, and internal page 3, Your Lordship.
Which one? Which paragraph?
It is 338, paragraph 6. You have mentioned that I state that it was agreed between first defendant and me that in consideration for the 100 new shares, the first defendant would pay $2 million United States dollars to the first claimant in the following manner, along with a contractual obligation of bringing 200 kg of gold as working capital within 10 days of starting of the company operations. So my question is, do you mean to say that $2 million plus 200 kg gold was the wholesome criteria for adding Snyder Prime Limited as a shareholder in the claimant number 1?
The 2 million that is in share premium, I need you to observe, nothing come to my pocket directly, everything to company. First of all,
of course.
2 million is going to put for company. If company go for liquidation, we are going to split it part at that time.
No, you're not understanding my question.
The 200
kg. Don't speak over each other. Gentlemen, please don't speak over each other. It's particularly difficult in virtual hearings because we don't have the normal interaction between human beings who are asking questions and answering them. So it's very important you don't speak over each other.
Yes.
So start again, Mr. Ghosh. Listen to the question, Mr. Sami, and try and answer it. You've been referred to this paragraph. You should have it in front of you, paragraph 6. You're being asked about this paragraph. Now, Mr. Ghosh, ask your question again, please.
Yes. So my question is, was it the criteria that to become a shareholder of the claimant number 1, the defendant number 1 has to bring in 2 million USD plus 200 kg of gold? It's not
100%.
100%, right? Okay.
For the 200 kg for 5 years.
Okay, fine.
Yes.
So actually, I had, Your Lordship, I had looked into the MOU, which was with the expert report. So I'll refer to that page because expert report contains all the MOU and the STA. So I'll take Your Lordship to Mr. Sami. I'll take you to page 741 of the. It's in the expert report. Page 741. Have you found it?
Yes, MOU.
Okay. It's a memorandum of understanding only.
Yes.
It says, if you go to page 741, the next page, share subscription.
Yes.
As far as I understand, share subscription is how much shares somebody will be subscribing to based on his contribution. So in this share subscription, it says first party, that is you, have established SAM Precious Metals, and then you, in the next paragraph says you own 100% of the shares in the JV. Next page, the second party wishes to subscribe, which is Snyder Prime Limited, 50% interest in JV company. So in order to effect this transaction, the parties agree that the JV company will carry out an increase in share capital such that the second party or an affiliate of the second party will subscribe for and be issued 100 shares, 100 new shares in the JV company, following which the second party will own 50% of the issued shares in the company. As consideration for the second party shares, the second party will pay 2 million United States dollars as follows. It breaks it up in two portions, 2 million. I'm not getting into that. The parties agree then that a sum equal to the premium account will be transferred by the JV company. And it ends with the first party agrees that the shareholding in the JV company shall be diluted in order to effect the above mentioned transaction. Regarding the gold, share subscription doesn't say that to become eligible to become a shareholder of the claimant number 1, the defendant number 1 has to pay or advance 200 kg of gold. Advancement of gold is a totally different clause in this MOU. Do you agree?
See, it is not here correct, but it's already, they make it as bare structure. They are preparing themselves to structure their company in DAFC to make a private fund, and they want to bring that one from their company, but it is part condition obligation on SPL.
No, I think I'm not able to explain to you.
Please.
I'm saying for Snyder Prime Limited to become a shareholder in your company as in SAM Precious Metals, as per the MOU, the share subscription clause only mentions that Snyder Prime Limited has to invest 2 million US dollars.
No, they have 2 million and link after with a condition to bring 200 kg.
Where? Kindly show it in this MOU.
Page 4, page 744.
Yeah. The second party shall provide 200 kg, 200 kilogram of gold, the gold to the JV company with 4.9 concentration, for the purpose of facilitating the operation of the business, the gold advancement, upon each of the following milestone occurring. Yes.
Correct. That is the point. Upon each of the following milestones occurring, not for becoming a shareholder with Snyder SAM Precious Metals. That is my question.
That is not true. What we agree, it is they want to bring it as per our agreement. This, as I mentioned to you, This things only shows the technique how to match with the fund later on, and they put it in this format. If you want also, please go ahead.
Yeah, no, it's fine. So you're saying this MOU is not correct?
It is correct. It's mentioned here, they have to bring it after operation start by 10 days.
Correct, after operation starts, but that is not a condition for getting a share subscription.
Whatever came out of the things how we are moving, it's more than enough for you to know its obligation on them.
Okay, now let's see the following milestones occurring. The full commencement of operations at the business as confirmed in a written notification by the first party to the second party. So when did you notify the second party? Can you show us that notice? Written notification, it says.
No need to look for much. We will go to accounts and see affiliated company when they start their transaction. We didn't see. I'll tell you one thing important, Mr. Shantanu, and for his owner to be aware. From beginning of the relation till share transfer, our communication was very casual. They are visiting us, the board of directors, at least per month, 3-4 times. Everything was very simple. When we go for share transfer, and after that, we move on, we found that is, no, SPL starts sending emails. We have to communicate with much professional way with them. So we start moving with that. What I want to say, our communication, just go for when we are start operation, and let's look his affiliated company when they start work with me. You can see that is automatic came for their notice. Not only that, I do want to say something I couldn't prove it, like how Mr. Shakti was with me in the refinery and subsidiary, meanwhile it's in operation.
So, sorry, you said, although you're not suggesting you sent a written notification in accordance with the MOU, as I understand your evidence, because you had very casual communications until later on. That's what I understand you're saying. But in addition to that, Mr. Shakti was with you in the refinery and saw the gold being produced.
Yes. Sharjah refinery, we were there. Yes.
Very well.
And not only here, also board of directors. Yeah.
Okay. So the second point number B at 7:45, you also agree this provision of 10 working days notice to the second party from the first party requesting the activation of the gold advancement, where such notice may be provided on any working day from 1st July 2018. This was also not sent.
That is also not sent. Yes. Everything casual, as I mentioned. And the easy proven from the accounts here.
Okay, so the clauses in the MOU are casual. That is what you're saying, right?
Sorry?
The clauses in the MOU or the entire MOU is a casual understanding between you and your company and Snyder Prime Limited.
Commitment is a commitment. We are a gold traders. Today, when I move by phone, any quantity with people, only by word, they know that one because they know your credibility and how you move. And this is well known for your dividend 3 as well. Yes.
Okay. Coming to the next point in the same page, the gold shall be returned by the JV company to the second party on the date, that is 5 years from the date of gold advancement. This period may be extended upon the written agreement of the parties. Now, you have already in your chief examination in chief mentioned that in the month of September 2018, 100 kg gold was provided by SPL, right?
Correct.
So, did you return this gold after 5 years? That is September 2023.
Let me tell you important things. Now,
you have already answered. You have already answered. You have not returned.
Well, he wants to clarify that answer, and I'll allow him to do so. Mr. Sami, you can explain your position on the return of the gold.
Sure. The gold, we kept the decision to keep it for life in the company, me and Rose's son, because importance of a claimant. One, for us, above everything in the world. Success is more important for anything. And we wish your dividend join us for this success, unfortunately.
Okay.
So you've kept the gold.
Kept it for life.
You've kept the 100 kilograms of gold in the
company. We are
company.
not going to take. Yeah. Till company liquidate, everybody take his gold.
Okay.
Your Honor, if apologize, Your Honor, there seems to be some confusion. I'm not sure whether Mr. Sami is following the question correctly.
Well, he's given his answer, and I asked him as well. I'm not going to allow you to intervene. I will. I want to be sure about this, so I will ask the question. Mr. Sami, do I understand you correctly to be saying that the 100 kilograms of gold that was provided to you not as physical gold, but as $4,900,000 at the outset?
I got the question. Sorry, I answer. I thought, just for a clarification, sorry, Mr. Shantanu, I thought you asked about my gold after August 2023, the 100 kg deployed by Roseson and by Sami. This is, we decide to keep it for life. But for SPL, we clarify all his account. He has no single gram at SAM. Already STA and board resolution, it's cleared. 5th of February 2021, you will see even the difference of $133,000 was a transfer for SPL. So he has nothing as SPL. I'm so sorry, Your Honor, and really I misunderstand the question. I hear it like a 2023. I'm so sorry.
I'm a bit confused, Your Lordship, because there's an admission that September 2018, 100 kg of gold was provided by Snyder. And there is also an admission that you can hear me, right, Mr. Sami?
Yeah, I'm hearing you.
Okay.
Yes.
Also,
September we received 100.
Correct. So again, there is also an admission. Let me finish. There is also an admission that post 2020 resolution, SPL has not been provided with their dividends.
You're confusing matters now, Mr. Ghosh. We're talking about a question you asked as to whether the gold had been returned, the 100 kilograms of gold, which was actually provided in the way of $4.9 million US.
Yes.
And that question was plainly misunderstood by the witness. And he's explained that as from the 5th of February, the date of the share transfer agreement, the first defendant did not have any investment in SAM, that its investment, the gold, that the money that it had provided in lieu of the 100 kilograms of gold had been returned to it. Is that right, Mr. Sami?
100%. And we discuss STA and everything cleared by STA. This is what I want to say.
So when did you return that gold? Or the value?
Everything retained for as per STA, they follow all of that one.
It must be reflected in the annual statements, I believe.
It's to go back to the associated company, you mean?
No, annual financial statements.
I will leave this. I'll tell you one thing. As what I mentioned to His Honor, anything technical on this regards, there is 2 board directors for SPL, as well also there is Mr. Anuj. Technically, they can show you the traceability, how they retain everything back to him. Completely, everything at SAM, really, not because I'm driving this company, but this is the company where reviewed by more 5 reviewers in different aspects, including financial and other things. Sorry.
Mr. Ghosh, I'm not sure, I'm sure you're not intending to confuse the witness, but paragraph 4.1 of the share transfer agreement provides that the working capital facility with a face value of 4.9 million arranged by ROSI through its associates and affiliates will be substituted by them with 100 kilograms of gold. So this was a replacement of the capital that had been provided through Snyder Prime by ROSI in consideration for its shareholding.
So the fact remains that the gold remains with Sam Precious Metals.
That is no way. Sorry, Your Honor. We are talking mislead totally
Yes.
mislead. I'm so sorry, Mr. Shantanu. You are going out of a track.
No, okay, you can explain.
Document resolutions. You didn't see the resolution of what happened in the resolution for February 21. You didn't observe the resolution on 30 December and how we are going to clean the account. Everything is clear. Your Honor, I don't know if you give me 2 minutes, Your Honor, but I'm afraid
it seems to me, Mr. Sami, that these are financial matters dealt with better by other witnesses.
Sure.
Mr. Ghosh, I'm not going to prevent you from exploring this, but as it appears at the moment, the share transfer agreement operated so as to substitute the investment that had been made by Snyder with an investment made by ROSI.
Yes, I understand that. So
I think it's better that you deal with this with the witnesses who can deal with financial matters when they come along.
And Your Honor, if you allow me, only I want to go for the resolution February 2021, where we resolve all of that and signed by board of director 100% and shareholder 100%. Yeah.
Well,
so
I'm sure that would
page 2018. Page 2018. Sorry, 218. Yeah. Shows fully. Yeah. If we look for the last paragraph before signature, I wish that Mr. Ghosh look for it, page number 220. So what's paid to Snyder? The balance after we advance them, we prioritize them by giving them mid-year and we didn't take, just to protect them from any risk coming from market. And that is well documented. By end of the year, their dividend came in net 2.833. He came and all his board came and they received the difference, 133. So because I got confused, always they said not receive a 2020 dividend. It's everything well recorded. Bank transfer of 133 already also is there. And in the top of the page, we said further resolve that the reference to board meeting 5th July 2020 related to distribution of interim dividend. Here when the advanced dividend 897, almost 900,000, we advanced him and we didn't take money just to support our partner. And that is now you tell me he didn't receive. Anyhow, this is, I don't want to take much, but I can't talk much on this area because unfair and mislead Mr. Ghosh.
Well, I was not left with the impression that Sam was still holding that investment of 100 kilograms of gold equivalent in cash following these financial arrangements. But it will be clarified, I'm sure, and tested by Mr. Ghosh if he wishes to do so with an appropriate witness who can speak to it. And also, in re-examination, Mrs. Bijoy is entitled to bring this document to the fore again and ask you questions about it, since it's been raised by Mr. Ghosh. So perhaps you want to move on, Mr. Ghosh, to another topic.
Yes. Kindly come to page 747, Mr. Sami. So there is a clause of definitive agreements, which says, as soon as possible following the execution of this MOU, the parties will use the reasonable efforts to agree upon and finalize the share transfer agreement, the shareholders agreement, and such other definitive agreements as may be reasonably necessary to put these terms into effect. What are the definitive agreements which you have signed or the parties have signed post this MOU?
It's good that before we talk about the character of our market, and it's very important now to tell you here, article of association in UAE, free zone area.
No, Mr. Sami, you're not answering. Mr. Sami, stop. You're not answering the question now. You've been asked a simple question. Where are these definitive agreements? I think I know what the answer is.
MOU became buying the definitive agreement.
Thank you.
May I continue?
Yes.
Yes, please.
Yes. Okay. I have seen in your second, witness statement also, and in the submissions also, that you have mentioned that Snyder did not bring gold directly from themselves. They borrowed from third parties and several other parties and brought gold, and that led to loans and whatever. So is there any clause in the MOU which stops them from doing so?
I'm not denying that they bring from a third party.
Yeah, of course. No.
Yes.
So only thing is, you're not, so they can bring, right?
They can bring.
Because in your witness statement, the reply witness statement, you have mentioned that there is nothing called Snyder Group. So Snyder did not give gold. Now, what is Snyder Group? That was your.
That is completely different. That is WhatsApp messages, current account customer, waiving account, moving, running account to mix paper. That is, it's really the time of his owner and our that. It's much more bigger to talk. That is so far from any reality.
So the basic question is, you have no objection, or you had no objection if Snyder brings gold from anywhere?
If they bring it and they bring it to the investment account as what they did for 4.9 convertible loan, third party recorded, I have no problem. But to bring for me gold for refining and say deployed capital, that is not the capital, Mr. And really, we are much more bigger than that. Now there is auditor, approved auditor, there is board resolution. I rely on mention message, mention deploy capital. That is only shows the volume, and deploy capital. If I will refer to the messages, really, I will find half of UAE partner to me, because all of them, they are bringing gold and refine. Is that deploy capital as well? There is a refine business account, and there is that. Now there is a customer yesterday. It's a great volume they brought for refining. Are they a partner at SAM? It is capital also called, but it's trading account business, not the investment account.
Where is this explained? Whatever you have just said, where is this explained in any of the documents?
Audited report, financial audited report, AFS, board resolutions.
Let me finish my question.
Yes, sir.
Whatever you just said, the nature of gold which somebody is supposed to bring in as an investor, is it reflecting somewhere in the MOU or the STA?
What? The WhatsApp messages or what?
No, of course not.
I didn't understand the question.
Please repeat your question, Mr. Ghosh. To make it clear that what you're asking about is what is contained or not contained in the MOU.
Yes, in the MOU as well as the STA, is there any provision which says that gold, only raw gold has to be brought?
No, we agree 4.9 million. It's facing the 100 kg. Yeah.
Okay.
And here also in the advancement of the gold, second party, because that's why we take a margin account. In the page 4, the second party shall provide 200 kg of gold to the JB 999 concentration. So this is what we define. Now he bring currency, it's up to him, but he has to put margin for it so we can use it. Because if he give me currency useless, I need gold to use it.
Okay.
So are you saying, Mr. Sami, that the correct understanding and interpretation of that obligation to advance gold is that it is to be advanced to the company's investment account, gold investment account, and
Exactly.
not gold in a trading account, even though it doesn't spell that out? You're telling me that is the proper understanding of it?
Yes, sir. Yes, sir. Yes, sir.
And the foundation for that contention is the business model that you've described to me and that is described in the expert's report of you having adequate gold capital or cash representing gold in the investment account so that you have an advantage over your competitors in trading and attracting refining business. Is that
Not
right?
only that, and not only that, yani now Mr. Shantanu asked valid things. Today, look down 5 years. Although that is, now when he bring from other parties, there is no condition he give it because between him and them, it is 5 years, but we are accepting. Yani we are very corporate partner. We are not denying anything. Yeah.
But this is separate from the trading business. This is investment capital.
Completely. Yeah, completely. I saw trial of what's up, no meaning. This is not the investment.
Very well.
Okay. So there is mentioned in page 746 that annexure 3. I mean, but the MOU doesn't have that annexure. I mean, did you miss it or?
Annexure 3 is there, should be there, maybe drop. This is a beautiful things, Annexure 3. When I got my business plan finished and everything, and I go and I submit it to authority and I got approval on it.
Okay.
It shows all things you wish to see about our project, including
where is Annexure 3 then?
It should be attached with the agreement.
It's not, Lordship, it's not there actually. That's why I asked this question.
We can attach it. We can ask Ms. Aisha if you can resubmit it. It will be highly appreciated. And
well, if it is part of the MOU, it should have been produced. So
yes.
I'll leave that with Mrs. Bijoy. That has to be produced.
Yes, sir. Yes.
And you can explain to me, Mrs. Bijoy, in an appropriate moment why it's not been produced.
Yeah.
Very well. Carry on, Mr. Ghosh.
Yes. So prior to when in the share transfer agreement, when the Snyder Prime Limited brings in Rosison, prior to that, did you have any transactions with Rosison directly?
No.
Okay. So coming to para 17 of your witness statement, it's 340, page number 340.
Which paragraph?
17, paragraph 17. So just this is more for my clarification. I'm also actually confused in some of the pleadings. Actually, you said initially the first defendant brought in 100 kg of gold in the month of September 2018. We all know that now, you have admitted also. Here you are saying in paragraph 17 the second line, which is the third line actually, the second sentence. However, second claimant agreed to the share transfer in good faith under the strict condition that first defendant and third claimant will each bring 100 kg of gold as the working capital.
Correct.
So this is what is actually confusing me, because 100 kg of gold comes in through this Rosie Sun or through Anuj Garg, who was at that point of time a preferential shareholder of Snyder Prime Limited in September 2018. Now, when Rosie Sun becomes a shareholder of 25% shareholder, again you are asking they will bring in 100 kg plus Snyder Prime will bring another 100 kg. So this is actually for my clarification. I wanted to understand what is the exact interpretation of this.
After STA, we claim all accounts. Convertible loan, third party, SPL loan. In the financial statement, we clean all accounts. If you want to go for 2021 financial year, and we can see that is everything clean and the fresh and new. Rosie Sun, they send their 100 kg. We receive it, and we are still waiting SPL.
So correct me if I'm wrong. As a person who doesn't understand your business or finance to that extent.
Yes, please.
Once Snyder Prime introduces Rosie Sun and gives Rosie Sun 50% of their own shareholding, you are asking total. Initially, you got 100 kg and now you're asking 200 kg. I mean, as a person who has no idea, I'm asking this question: is it right or wrong?
Very easy. MOU to dilute my share 50%, 200 kg. When he came and he told me lender and the creditor behind him and he's in risk, although the agreement not allowed any of us to sell share, I accepted and they go for the share transfer. Now the only obligation I need now 50 share I sold, I diluted or I sell it to them, is still obliged to bring 200 kg. 25 kg they agree on the Rosie Sun, 25 kg on the SPL. So both of them obliged to bring 200 kg for some precious metal. So and after STA, we claim make account zero, very zero everybody, including you see your defendant one, all their accounts cleaned. Then we receive from Rosie Sun till end of the December, we didn't receive from SPL.
Okay. So since 2021, initially I mentioned 2020, I think that was a mistake. Since 2021, Snyder Prime Limited did not get any dividends, correct?
Since 2021, correct.
Okay.
Based on the offer, they give it to us as a shareholder.
So they offered that, please deduct our, we do not want to.
Yeah, 100%. You see all board is witness and sign it, plus all shareholder, 100% of both.
Okay.
And but for your information, after that also, there is 5 February, they came, Mr. Shakti came and signed with his shareholder, with his board of directors. And
yes, I've seen those documents, yes.
Then on 15 September, they came, send Mr. Dino and witness the first dividend, and they sign also the share board of resolution. And Mr. Dino come with a letter from Mr. Shakti, he can sign on his behalf. 15 September resolution.
15th of September 2020.
Correct, sir. Correct. Yes. And the letter, I guess, Ms. Aisha already attached. That Mr. Dino come on behalf of both. And we call them for shareholder meeting and board meeting. They rely on the type order. They mentioned board meeting and the 15. That's why they said that is 15 September. We didn't sign. But in all cases, the document 191, if we can go for it, please. This is the letter brought by Mr. Dino when he come on 15 of September. Signed by check.
What page again, Mr.?
191.
191.
Yes, sir.
And
yeah, this is his authorization, correct?
Correct. Where Mr. Dino on 15th of September, or exactly first day September 2021, came, signed the draft of mid-year financial, as well also witness the dividend distribution, plus signed the agreement or approved the Sharjah closure after we took him to the new place. We investigate, we visited, we walk, we have a nice time, everything we sign. Then you know what happened.
You're dealing with the Sharjah shutdown now.
No, yeah. I combined both refinery under one beautiful building. So
Yes.
we called their representative director to visit what we are doing and witness what we are doing on the ground. Because achievement of SAM is not normal. It's visible worldwide now. Alhamdulillah.
Very well.
Okay. So will you be able to show from the audited statement 2018 how much investments the investors made in your company, including Snyder Prime Limited, you or third parties?
Yeah, 2018 financial report, you mean?
Yeah, I'll take you to the page. It's 771.
771. Yeah. You go for page, can we?
Which page specifically? This is a lengthy document. Which one do you want him to look at?
Yeah.
So I'm also not very certain because I want him to show the investments which he had made.
Sure.
And any other person apart from Snyder Prime Limited.
What again your question? I didn't get you, Mr. Lab. You confuse me. You want me to show you how much they deploy? It's 4.9. It's visible.
No, not
if
they.
You have another question? How much they deploy here or they pay? It's a premium account. Yes.
Sorry. Not they. It is either you or some other third party apart from Snyder Prime Limited.
For what? For the 2 billion premium?
No. For investments in your company.
Yeah, it is 4.9. It's from convertible loan, third party. This is
Mr. Sami, you're misunderstanding, but the question is not being asked very clearly. I think, Mr. Ghosh, you are asking where in this document any investment by Mr. Sami is shown. Is that correct?
Yes.
Right. Mr. Sami, you are being asked by Mr. Ghosh to point out in these financial statements where any investment by you is shown in your company.
I sold 50% of my share against this investment. What the SBL debited were 2 million premium account, as well also here it is, if you look the 100 kg they brought, it is a short-term investment or 5 years lockdown investment. It is not my goal. By end of the 5 year, they can take it, and it is non-depreciated. It's fixed amount.
So you're admitting that apart from that 4.9 million, there was no other investment in your company, not even from yourself.
I didn't admit. It's enough for you. It's enough for you as SPL to be part in SAM, because SAM, not anybody can be achieved to be inside. It's very expensive refinery. That's why your appreciated defendant, see how much he generated from his, and we are happy for him. And still we will be happy for him if he became also more corporate partner. I believe you have to put straight for a question. Otherwise, I can really write a storybook about what we face from SPL, from their default, from non-corporation. But
all right, Mr. Sami, I think Mr. Ghosh, the point is being made that this business of SAM is Mr. Sami's conception. He set it up. He had 100% shares in it, and for its value and prospective value, he was prepared to part with 50% of the shares, dilute the shares, and then part with 50% of them to Snyder Prime for a consideration and an investment. And it's for me to decide what that investment was or required under the terms of the MOU, if it's binding, and or the STA. Does that not summarize the position clearly?
To some extent, yes, but it has been argued quite vociferously that if some partner is not contributing, then steps should be taken. So the question was, the main partner with 100% shareholding did not have anything to contribute to his own company. So he had to take help from outsiders. So that's the question, actually.
Yeah,
Well,
I believe the help giving to SBL, it's more than enough. The
Very good.
amount we retain it to SBL, imagine if your company, a defendant, not receive the 2.7 million or 11 million or 2.5 million. Imagine that position. Let's look for the truth. Is that value?
Right, we're not going to
nothing?
debate the, we're not going to
Sorry.
debate the merits of contribution.
We are
Stop.
under your we are under your let's call it consultation, and that they should respect to whom to talk and how to talk. Sorry,
Very well. Just
yes.
we'll terminate that debate there. Mr. Ghosh, do you have any further cross-examination?
Yes, a little more.
I was intending to take a break mid-afternoon. It's 4:30 there now for people's comfort, and you perhaps, Mr. Ghosh, to gather your thoughts to finish off your cross-examination. Will you finish your cross-examination by 5 o'clock Dubai time? What is it? There's 4:30 now.
Yeah, I should. I mean, we are there till 5:30, right? I mean, the timetable is up to 5:30.
I thought. Just checking the timings. Well, I'm looking at your timetable. The timing seems to finish every day at 5 p.m.
5 p.m. Yeah, I'll finish it by 5 p.m.
Very well. Well, we'll take a short break now for 5-10 minutes. And if you go slightly past 5 p.m.,
yes,
that will not be a problem. Very well. We'll adjourn for 10 minutes just now.
Yes, yes. And Mrs. Sami, there is nothing personal here. So
don't
take
an
an offense.
at all.
Gentlemen, I'll leave you to have your greetings. Indication.
Ms. Bijoy, if you don't have that business plan also, we have the signed copy also, because you had annexed it, we didn't annex it because it will be duplication. So we can share it with you.
So Your Honor, what had happened is this document, because of the duplication, we deleted one version of the MOU, and the version of the MOU that got deleted had the Annexure 3. So apparently, currently that Annexure 3 is not in the bundle. With your kind permission, we can replace the existing MOU version with the one with the Annexure 3.
Yes, well, don't provide me with a whole new bundle. There is, in fact, a new bundle on the case management platform, which adds the skeleton argument and authorities submitted by Mr. Ghosh. But I had worked extensively on the original bundle of 1,343 pages. It's now 1,300 and more. So please just send me the additional document as a PDF, and I will insert it into the bundle.
Sure, Your Honor, we will do that.
Good. So, Mr. Ghosh, please continue.
Yes. Mr. Sami, kindly come to page 787. This also, I need your clarification in case you feel that this clarification will be provided by somebody who understands finance better. We have no issue. We can wait for that. In page 787, we have this convertible loans. Point number 13. Have you found it?
Sorry, yes, I'm on it.
Yeah. Page 787.
Yes. Note 13, convertible loan.
Yeah, correct. 787, 13. So we have two items here. One is convertible loans from related party, refer note 17. We discussed this in the morning also when Mrs. Bijoy was arguing. And then
Correct.
convertible loans from third parties, which is 4.9. This is also clarified. There is no doubt on that. Now we go to page 791. So convert again in liabilities, under the heading liabilities, if you are there already, we have convertible loan from related party 1041711. And the second item is convertible loan from third party, which jumps up to 6.9 million.
Yeah. See, of course, I prefer this one to go, but most probably will be a customer bring the gold for long term here in SAM, but definitely not SPL.
Okay. So again, then we go down to again 7.92, next page.
Sorry, I haven't got this clearly. What you're saying about that 6.95 million convertible loans from third parties, that's you're not able to say which third parties that is from.
No, sir. This is accumulated, the 4.9 plus 1.0404. I said if there is extra from that amount, will be some people come, for example, for short-term trade with us. Short-term trade. Customer, he said, now I'll deploy and we go for them. Example, I have a capability to buy 10 kg. Customer offered to me 20 kg. I offer my customer, I told them, by the way, I have opportunity, other customer who buy my finished product. For our trade, there is two links. One, to buy raw material. Second, to sell finished product. Finished product party, sometimes we go with them for short term to enhance our liquidity. So we ask, we say there is opportunity 15. I'm going to buy 25. Would you like to buy with us? He said it's okay. So he buy in advance. Sometimes this advance it goes for 1 month, 2 months, 3 months, based on the opportunity existing in the market. And this is, yani, we are doing with several times with different people to improve. And this is where make us split our profit, because instead, if I have my 200 kg, I can earn the both, yani, full spread between buying raw material and selling finished product. Yes. But now, because of lack of or obligation of my partner to fully fill his commitment, sometimes I'm doing this to enhance the liquidity and not losing the trade and make the refinery the busiest refinery, because all raw material I buy need to refine. That is different charges also.
I understand that, but in this figure of 6.950 million, yes, there will be funds supplied to the company from trading parties, not investing parties. Is that what you're saying? Exactly. That's what you're saying. Very well. Okay.
Okay. So,
and can be clarified with the other technical people.
Yes.
Director, because all of them.
Sure. Sure. So going to the next page, 792, correct me if I'm wrong, Mr. Sami. This 6.9, which we just discussed, is it the same figure which we find at item 3, 4.9 and 2050198? Because if you add, I think it comes to that figure only.
Yeah, if it, yani, see, as I mentioned, it's not my area. For me, I'm looking always for B&L and balance sheet. But anyhow, this is can be more validate by people next to me. But it seems yes.
Yeah, but you just mentioned in page 791 that 6.9 Snyder Prime Limited has nothing to do with it. So that's why I asked you the question, because it's already
Snyder all the year 2018-19 they deploy here only a short term 1 point directly, the 1,041 for their affiliated company trading. Rather than that, Snyder no. One time I remember there is one time That is, there is a company came, but at the end, we are the one who paid the profit share of it, Sam, not Snyder. So we couldn't deal with it. And also they came for a short term. And that company brought by me. It's named Vin Gold, yes. Yeah, that is different.
Vin Gold.
Yeah.
So you're saying
Sorry,
this to...
sorry. What was the name of the company?
Vin Gold. Yeah, but I don't know, Your Honor, I don't know such this. I feel sometimes it is what we call it. It's for sensitivity to mention other people name. Is that fine? I don't know, because we didn't take permission from them.
Well, these are open court proceedings, not arbitration. The documents are they're available for inspection on the court platform.
Sure.
So it is a feature of litigation that it is done in the open, which doesn't just include what is taking place between us today. It includes also the filings, so and documents. So don't worry about that. But this was, I've spelt it Vingold, Vingold. Is that right?
Yeah, VIN Gold.
And you're saying that the transaction involving that company, which introduced gold into your company, was a trade in which you were required to share half of the profits or whatever percentage with
for
Gold.
3 months they came only, and they didn't be happy, because in our business we are working on high volume, small margin. They didn't enjoy it, so they didn't continue, because this one should be profit. It's from your money. Now when you split it, people not enjoy the profit. That's why it came short term and they left. And all profit generate, I made all my product Sharia product. So everything generate already giving to them from Sam, not from Snyder.
Very well.
Yeah.
Well, we'll hear no doubt more about this from another witness in due course.
Yes.
So that's page.
So just one more observation from page 792, Mr. Sami. It is the case of the defendants that under item 3, convertible loans, that 1041711, it's Snyder directly, as you said. 4.9 was a preferential shareholder through Rosie Sun when they were the preferential shareholders of Snyder Prime Limited. And the 2050, as you mentioned, Vingold, which was...
I'm not sure this one Vingold.
No, I'm telling you, this is the case. This is the case of the defendant.
Could be.
I will say it. You're right. It was brought through Vingold through Snyder.
Sorry, this is
brought by Vingold through Snyder Prime Limited. That is the case of the defendants.
But go make sure that is, if it is who paid that profit for them, that who from where they paid. It's not from Snyder. Like this, you help me. We are in compensation to claim it back from them if they deal with it like Snyder.
So do you have an arrangement directly with Vingold?
Yes.
Can you produce the document?
The paper prepared for SPL. The paper prepared to SPL. But reality, profit gone from us. You understand?
If they're investing in you, profit will go from you only.
Yeah, the profit is gone from me. Exactly. And I guess I'll try to ask Ms. Aisha after we talk with the accounts to prove how much we pay them. Yes. And if you have any document shows that they pay the profit, I'm more than happy to say this is their investment.
If your lordship allows the defendant this 2050198 investment, which got deleted in the process of redaction, we can produce that.
Well, you produced, I think,
and this is short term in all cases.
Stop, Mr. Sami, just a moment.
Sure.
Mr. Ghosh, I have come across WhatsApp messages that you've referred to indicating this transaction. That's not the issue so much as whether this was investment gold or gold which came into Sam's possession on its trading account. pursuant to which it was required to pay a portion of its profit over on using the gold to that entity, Vingold. Now, the document that you're asking to be admitted, which has been deleted, does this deal with this difference between gold being brought in as an investment and gold being brought in by a trading partner, where Sam has to pay a share of the profit it makes in using that gold, or not? What does it demonstrate, this document you want to adduce?
So for that, I need to take instructions from Shakti Chauhan. So probably I can come back to you tomorrow on that.
Yes, certainly you can. I think this distinction is becoming clear now between gold provided for investment purposes, which Sam can use without sharing the profits with a trading partner who is bringing gold into the company. Do you see the difference, Mr. Ghosh?
Yes, I do.
Well, I'll give you an opportunity, subject to any objections. If it was omitted by mistake in the filleting process that we have that I directed, then it's likely that I will admit it. You've actually mentioned this, I think, in your skeleton.
Yes.
This is on page 3.
The defendant's case is, if you add all these three, it comes to 7.9 million in 2018, which is more than 200 kg of gold.
Yes, well, we'll see what you produce tomorrow, and you can take it up with a better witness. No disrespect, Mr. Sami, a witness better qualified to deal with the financial aspects.
Exactly.
As he has candidly conceded, is not his forte.
Although Your Honor, all board resolution shareholder is crystal clear. But anyhow, I'm more than happy to.
Very well.
Yeah.
Carry on, Mr. Ghosh.
Okay, so okay, so basically, you're aware, Mr. Sami, that and in fact, one of your defense in the other cases is that you didn't provide the statements, financial statements to Snyder Prime Limited. The defense was they didn't provide you the KYC, the change in shareholding from Shakti Chauhan to his wife Phoebe Tucker, right?
Correct.
What's the, Mr. Ghosh,
No,
what's the relevance of this?
It's not just a suggestion that. So
this
anyway,
is this is not relevant to the issues I'm trying at the moment.
Okay. So anyway, I think that's done for today. There are no other questions.
Well, Mr. Ghosh, if you want to submit this document that was inadvertently excluded, can I ask you to provide it to Mrs. Bejoy overnight?
Sure.
She probably knows what it is. I don't, obviously, but can you arrange to discuss with her whether it may be admitted? And if it is to be admitted, you can file it and I will look at it tomorrow. And it's something in any event that you would be able to deal with in cross-examination of another witness who is in a position to deal with financial matters. So we'll leave it there. Very well. So we have your re-examination first thing in the morning, Mrs. Bejoy. I think we'll finish there for today. It's just coming up to 5 o'clock in Dubai, is it not?
Yes, 3 minutes.
Yes.
I don't presume you could finish in 5 minutes, would you, Mrs. Bejoy?
I have only 2 questions, Your Honor. We can conclude it in maybe less than 5 minutes, so that tomorrow we can start fresh with Mr. Anuj. Sorry.
Anuj.
Anuj. Confused.
Right. Well, if you can finish quickly, then we'll finish, and then Mr. Sami's evidence will be complete.
Yes.
Yes, Your Honor. I have only one or two questions, Mr. Sami. Can I please refer you to paragraph number 9 and 10 of the bundle? Sorry, 9 and 10 of the particulars of claim. That's on page number 18 of the bundle.
Yes, I'm on it.
Could you please go through these paras and tell the court whether these were investments that you have made to the JV company?
Yes.
Can you list down the items, please? Can you read it out? What was the contribution?
Mrs. B. Joy, I've read this, and indeed I was alluding to it when I intervened with Mr. Ghosh's question about what did you put into this company in effect, and this is what Mr. Sami put into this company.
Yes, Your Honor. So I will then move on to the next question.
Yes, I think you should.
Because these paragraphs are very clear on his investments.
Yes.
Can I now take you to the share transfer agreement, Mr. Sami, paragraph number 4, which you will find on page number 91.
Okay. Yes.
Could you please go through paragraph number 4.1 and explain this to this court, why you had to return the 4.9 million and when it was returned?
See, this one, as we mentioned, it came from a convertible loan from third party on behalf of SPL. After that, can I see that is, yeah. Then when we come with the final STA, everybody should bring his 100 kg. So that's why we claim all that 4.9 for all third parties, they were contribute on that investment. Yeah. Do I understand your question? This is what you are asking, or
no?
Yeah.
I think I will need a bit more of clarity from you, Mr. Sami.
Yeah.
This paragraph is talking about, if I may read it, the working capital facility with a face value of US dollars 4.9 arranged by ROSI through its associates and affiliates will be substituted by them with 100 kg of gold, which will continue to be maintained by the company. Now, my question is,
correct.
ROSI, why did ROSI have to bring 100 kg gold when there is already 100 kg in the company?
See, the 100 kg in the company already retained as per STA agreement. This each.
So when did you return it?
It's retained. It's in the if you look at all the accounts clean. I'm not sure which is the technique, how the financial, but we clean all accounts, so nobody bring any investment. Then Rosie brought their 100 kg.
Okay, yeah. So let me pause you there. So meaning the 100 kg was returned sometime in February 2020.
Yes.
You agree with me?
Yeah, there is a board resolution. We read it just now. Correct. Yeah. I wanted. Yeah.
Sorry, I'm sorry, Mrs. B. Joy, you're confusing things now. You say the 100 kg was returned. In precision, you mean the 4.9 million representing 100 kg was returned?
Yes,
correct?
I stand corrected, Your Honor. Yes, I make my question more clear. So, Mr. Sami, would you agree with me that the 4.9 million, which was the cash equivalent of the 100 kg gold, was returned sometime in February 2020?
February 2020. Yes. Yes.
And why was it returned?
It's returned as per the STA agreement. If you go to the condition,
why you had to enter into an STA? Why there was an STA?
No, today I enter STA for two things. First of all, I bring all my board of directors. We enter first of all to assist our existing partner how to come over of his challenge and witness all the challenges and how they are settled.
What what challenge are we talking about for the existing partner?
It is the obligation 11.8 plus 2.5 from market participants is a huge challenge. And our brand on risk if we didn't interfere on this area. As well also, after that, we want to make sure also Rosy Sun, sure they are going to follow MOU terms and conditions.
Okay, okay, thank you.
So, Ms.
And
Bijoy,
if you would like, sorry, yes.
Sorry, Ms. Bijoy, are you going to show me the documents which demonstrate the return of this 4.9 million to the parties by whom it had been provided or to the party through whom it was provided?
I might not have a direct document, Your Honor, but I would like to highlight the entries in the annual financial statements.
Yes, well, you can do that either now or in your closing submissions to demonstrate that this was returned and it's not been retained, as I understand is the claimant's case.
Yes, Your Honor. Yes, if I may, with your permission. Sorry, apologize, Your Honor. You may please continue.
No, I was going to leave it to you as to when you point to the relevant documents which substantiate the evidence that's just been given, that the accounts were cleared, that this was returned, and it was, as it were, starting from scratch with the STA. I understand what the case is, and I've heard the evidence of Mr. Sami, which I will have to decide upon, but I've also heard his assertion that there are documents which verify these transactions and the return of these funds.
Yes, Your Honor. With your permission, Mr. Sami, could you refer to bundle page number 841, which is the extract from annual financial statement for 2020.
Okay.
And if you could please focus on item number 14, on the convertible loans.
Yes.
841.
As you can.
Yes, it is cleaned here. It shows very clear, Your Honor.
If you may please allow me to elaborate.
Yes. Yes.
Your Honor, Mr. Sami, you agree with me that there are two columns there. One provides for 2020 and the other one on the right-hand side provides for 2019.
Yes.
Correct? And you agree that the working capital cash equivalent for the 100 kg gold of 4.9 million is reflected in the column that deals with 2019 entries.
Thank you. Exactly.
Correct?
Perfect. Yes.
Whereas in 2020, the corresponding column is vacant or blank.
Yes.
What would that mean according to you?
That is mean it's paid back, If could we go for the top of the column? So, yeah, 2019 is there. After they sign the STA, everything is cleaned. Not only that, you hint me very good point. If you look for B, due to related party, it's also the 1,041,000. It's already clear as per audited financial report. Yes.
Yes. Yeah,
you are referring
to.
Yes, that's item 12B you're pointing to as well.
Yes. Yeah.
Which so that substantiates the two transactions which are described in paragraphs 4.1 and 4.2 of the STA, the return of the convertible loans to Snyder Prime, 1.041 million, by the means there specified, 291,711 to Snyder itself and 750,000 to its related
third party.
Snyder affiliate. So that's why that figure has disappeared in the 2020 accounts. And then the other figure, the convertible loans, the 4.9, arranged originally by Snyder, that also has been paid off.
Yes.
Correct.
Well, you've done it very quickly then, Mrs. Bijoy, to show me the documents. Very well.
I'm grateful, Your Honor. That's all, Your Honor. I don't have any further questions for this witness.
Very well. Just give me a moment before I let the witness go to see whether there's anything else I want to ask him and to complete my note. Right, just give me 1 second, please, Mr. Sami.
No, take your time.
While I check my notes. No, I think everything has been dealt with. So your evidence is complete, Mr. Sami. I should tell you that you shouldn't discuss matters, your evidence, with witnesses who are yet to come and give evidence before me. And you'll understand why that is. They must give their evidence independently. And we will resume tomorrow morning at 11 o'clock.
Yes, Your Honor.
Thank you, Your Honor. Thank you.
I'm sorry you all made the mistake. You were all sitting there for an hour waiting for me, but the problem has been resolved, and we'll get on with it. We've not actually lost much on your timetable because you've been very efficient this afternoon. So there was a provision for Mr. Anuj.
Yes.
Yeah, but that's how far behind we are, but I'm sure we will catch that up as the days go on.
Yes,
Thank you very much, all of you, for your care and attention in dealing with these matters, and we'll continue tomorrow morning. I wish you all a good afternoon, good evening, and see you in the morning.
Thank you.
Thank you very much, Your Honor.
Thank you.
Thank you.